Well, good evening to everyone. Happy Friday. We've made it through another week. We've made it through another week indeed. It is Friday, November the 3rd. It is somehow the month of November. It is the month of November where I am in January still. And with how cold it got in the past few days, I feel like January is appropriate. Where did the year go? I have no clue. Time is a concept I have yet to embrace. Thus, kind of the fact that we're in November. So, anyways, glad to see you guys are here. Very, very cool. For those of you who are joining in, why don't you go ahead and hit the like button on your way in? And please, if you haven't subscribed yet, please consider doing so. What are you doing? How was your week? Where are you tuning in from? Are you having a cocktail? Are you having a beverage? Are you having some tea? Are you having some water? Do you have popcorn lined up? I don't know. Talk to me. Talk to me. Let's see. What are you guys doing today? Philosophical today, Rob. I don't know if I'm philosophical or not. What is this time you speak of? I don't know. Clearly, you guys noticed that I'm a little bit late. Here for years makes the appropriate comment. Rob is never late, nor is he early. He arrives precisely when he means to. Thank you, here for years. Very much appreciated. I see people are coming in from Recovery Addict. Hopefully, you guys have been watching the Maya trial on that particular channel. If you have been watching it, I've been doing recaps, and that's going to be the first topic we talk about today. But just kind of to give us a little bit of what's going on and where things stand. I had a heck of a week, man. Wow, what a week! I So between the practice of law, I was in court this morning. Successful outcome. Opposing side didn't show up. Motion was granted and order entered today, so that was very helpful and lovely. Practice of law. I have a trial next Wednesday. I'm out of town on Monday and Tuesday, so it's stressful, and I operate based on a lot of stress. Oh, this is one I wanted to catch up because this might be a topic I'm going to chat about in a minute or a little bit. Working in Oklahoma City, we might talk about that Oklahoma judge at some point in time this evening. Not sure, but we might talk about that Oklahoma judge because the Oklahoma judge filed a response. And I have the response, thanks to one of my law partners who practices in Oklahoma, who sent me the response. I was like, this is great. I don't know if great is the right term, but it was fascinating to say the least. But that is kind of where the week has gone. The week has gone to a lot of the coverage of the Take Care of Maya case. I saw the jury came back and Sam Bankman. Fortunately, though, because federal court doesn't allow cameras in the courtroom, wasn't too much I could do other than just read on Twitter what was going on and just regurgitating from tweets of what's going on in the courtroom. I didn't feel like it was adding very much. And plus, the Maya trial was something I was very fascinated in. So my brain is playing catch up right now. It's playing catch up. It's in like 9 different places at one time, but that's the ADHD superpower. So happy Friday to all of you. Happy Friday indeed. There are, you will notice that a certain Canadian was on the thumbnail. Certain Canadian was on the thumbnail for the stream tonight. And that's because this said Canadian is a dear friend of mine who is actually having his charity live stream tomorrow. Where are you, Mr. Runkle? Let me see. Let me see if I can't pull that up real quick. There's Runkle of Bailey. Why don't you come in here and hang out with us for a second? And not you personally because you're sleeping, because you're going to do a live stream. But so there's the charity live stream that's set up for tomorrow. It's a 24-hour live stream. I have done some long live streams, but I've never done a 24-hour live stream. This is the Extra Life charity event, and it goes to benefit the Children's Miracle Network hospitals. Ian's hospital of choice is the Stollery Children's Hospital, and the Stollery Children's Hospital has a very special place in his heart. So I will tell you that every dollar that is earned in this particular live stream tonight is going to be donated to that charity. So I've left the super chats open because I wasn't able to set up the funding link to a third-party charity that's on Ian's channel, but I'm going to keep track of basically all of the all of the super chats today. I'm going to go ahead and donate that tomorrow at some point in time during the live stream. I'll be on with him probably around 10 a.m. my time, 10 a.m. Eastern, doing a little bit of Dungeons and Dragons. So people are asking for clarification. Ian's live stream begins in, let's see, what's the math? You can do math, Rob. 8:44, 9:44, 10:44, 11:44, 12:44, 1:44, 5.5 hours. So in 5.5 hours, Ian's going to be on live for the next 24 hours, the entire day of Saturday, November 4th. So please consider donating directly on that link. The link is pinned to the top of the chat. It's also in the description of this particular video, so you can see it and donate to it. Let me see if I've actually got that. Might be able to share. See where we are, Mr. Runkle, because hasn't even started yet. Hasn't even started yet, and he's already earned 5,000 towards his goal of 50,000. Last year he crushed that goal, and we're hoping that he's going to do it again. So I can see there's already several donations. Look at that, Greginator, already with a really generous donation. So guys, please consider donating if you can. If you cannot, that's fine. That's fine too. Just watching will be ample support for Mr. Runkle. So that is what we've got lined up. That's why Mr. Runkle is on the thumbnail tonight, because I wanted to shout that out, and I wanted to basically make it very well known that all the proceeds from tonight's live stream are going to be donated to that charity. That's going to make me happy to do. And it's making a lot of you happy too. Brentwood Chic, thank you for Ian. Because of that, I'm probably not going to pull up some of the super chats. Some, because we have a lot of content to cover, and I need to sleep because I need to be up in the morning to help Ian out. I'm going to be donating some pens that I have made, 4 or 5 pens. I haven't decided which. 4 or 5 pens I'm going to donate to be auctioned off live on that charity stream. So please tune in if you can. I will try to go on Twitter and on the socials with pictures of the pens that are being donated, and I'll try to give you guys a little heads up of when they're going to be donated, when they're going to be auctioned, so that you guys can see. Okay, let's get into some of the commentary. I see that people are rating from the behavioral arts. I was on with Spidey a little bit earlier. We were just talking a bit, having some fun, doing some live analysis, which Spidey doesn't like to do. He did some analysis of his own behaviors, which is always fun to do. So let's get into some of the Maya coverage and kind of give you guys an indication of where we are now. So swoop. All right, so I've been covering the Take Care of Maya case. It was a case that was documented in a Netflix documentary, aptly called Take Care of Maya, involving Maya Kowalski, who was at the age of 10 when she was admitted to Johns Hopkins All Children's Hospital, JHATCH for short, on October 7th of 2016. That admission came after she had been diagnosed the year prior with CRPS, complex regional pain syndrome. The hospital began to question the diagnosis upon her admission. She was admitted with acute stomach pain, and in doing some of the medical history, the hospital learned that Maya had been receiving doses of ketamine as a therapy for that CRPS. The hospital engaged in a back and forth with Department of Children and Families. A shelter order was entered after Maya had been hospitalized and sheltered for 87 days, 87 or 97, 3 months. On January 6th, at a hearing at which Beata Kowalski, Maya's mother, attended, the judge precluded Maya from hugging her mother. The next day, Beata Kowalski, Maya's mother, took her own life. There are claims of false imprisonment, battery, negligent infliction of emotional distress, intentional infliction of emotional distress, and then this trial has been going on for the past 6 weeks. We're at the close of the trial, and we had some very interesting developments on the very last day of evidence. Well, what we thought was the very last day of evidence, which was Wednesday of this week. And well, yeah, let's start there, because we got some back and forth. Yesterday rather, between the judge explaining some of an inquiry. So I covered on a live stream recap 2 days ago that on Wednesday in the plaintiff's rebuttal case, the plaintiff began eliciting testimony about a possible joint commission issue. The hospital had placed a witness on who testified in their defense that the hospital was well and good with the joint commission, which is voluntary, but also with CMS. It turns out that the hospital was not all well and good with the joint commission. There were previous reports. There was an inspection, surprise inspection, that resulted in the hospital, well, being found to, imminent. Forgive me, my brain is trying to play catch up. The hospital basically said we're well and good with the commission. The commission had said that the hospital was at great risk of losing their accreditation, losing CMS accreditation, imminent jeopardy of losing their accreditation. And that was because the Joint Commission found that there was egregious and widespread concerns with patient safety. I did not know this because I'm not local to the Tampa area, but apparently the hospital in 2015, 16, 17, 18 was having issues with the Heart Institute, which was a part of the hospital. But the Joint Commission report seemed to go further than that, seemed to suggest that there were systemic issues with the hospital. The judge was not too pleased with the fact that the hospital had put a defense witness on, and that defense witness testified to the jury that the hospital was above board. Everything was fine. So the judge basically said, nope, we're opening discovery. We are at the very last day of trial, but we are going to open discovery. And the judge said, hospital, you must produce all of the records that are requested, and you have to make a corporate designee sit for a deposition. That deposition took place today at 4:00. The hospital was ordered to turn over a ton of documents prior to that deposition. And this gives me an opportunity to discuss depositions and what is a deposition ducis tecum. So this was the notice that was filed by the plaintiffs in the case, seeking to compel the deposition of a hospital representative. The judge had graced this and said, nope, you are sitting. J. Hatch, you are sitting for this deposition, and these documents are going to be required. So plaintiff's notice of taking video deposition ducis tecum, which means deposition, bring the docs, of defendant's corporate representative. Please take notice that on November 3rd at particular address, one of your corporate designees needs to sit for a deposition. It's being taken for discovery purposes, use at trial, other lawful purposes permitted by the applicable and governing rules. The deposition already took place, so I'm not concerned about the address being shown at this point in time because it's already concluded. So the issues and matters on which the examination is requested, right there. So what are we requesting the examination for? 1, any and all interactions with and or surveys conducted by the Joint Commission, CMS, Center for Medicaid Services, AHCA, or any other similar accreditation or governing entities between 2012 and 2019. Any and all corrective action plans and or similar improvement efforts undertaken by J. Hatch at any time between 2015 and 2019. And any and all self-reports and or findings, surveys, reports, and or classifications of immediate jeopardy and the reasons therefore, signed by Greg Anderson, November 2nd, 2023. Now, in a deposition ducis tecum, you can tell them you need these particular documents prior to the depo. So basically, they're looking for any and all reports, surveys, etc., issued at any time between 2012 and 2019, all preliminary findings from the Joint Commission, all preliminary reports from the Joint Commission, all prior surveys by the Joint Commission, all preliminary surveys, any and all self-reports, any and all corrective action plans, any and all findings, reports, surveys, indicating a classification of immediate jeopardy from either the Joint Commission or CMS between 2012 and 2019. Any and all internal communications, emails, and or memorandums concerning a finding or classification of immediate jeopardy issued by either CMS or the Joint Commission between the senior vice president, and executive vice president. All the documents. All the documents. Any and all reports, surveys, findings, and or corrective action plans accessible via the Joint Commission's web portal, print out of the Johns Hopkins All Children's Hospital web portal and or other similar interface with the Joint Commission showing the documents available to J. Hatch and the date accessed. Any and all emails, letters, and or written correspondence between the Joint Commission and any individual at J. Hatch holding the title of vice president or higher within the last 72 hours. This one is curious. I found this one to be remarkably curious. So not only are we looking for the stuff in the past, but in the last 72 hours. Once this was disclosed, once we discovered that this was a particular issue and your defense witness might have testified, well, in a misleading fashion, we want all communications. Give us everything. And they're going to get it. They're going to get it. And, emails, letters, and or other written communication between CMS and any individual at J. Hatch within the last 72 hours. I love this. Anything with a scintilla of order relating to the Joint Commission and or CMS indicating a classification or rating of immediate jeopardy at any time between 2015 and 2019. Anything having to do with the run-up to the finding or classification of ongoing immediate jeopardy. And, internal policies or procedures concerning the Joint Commission. So literally everything. Give us all the material. So that was remarkably interesting. And the judge got the chance to elaborate. And you guys, I'm not putting the trigger warning up because we're talking motions practice right now. I'm not going into the facts specific to Maya's case. We're talking motions practice, so I'm not going to throw the trigger warning up. I have been doing that in the recaps when we recap testimony, but we're not talking about that right now. We're talking about just the motions practice. Okay. What are we talking about, though? Are we talking about, let's see. Come on, Judge. I need you. I need you, Judge. Because when they were having arguments over jury instructions, this issue came up. And the judge expressed himself as far as what he thought was relevant and should be provided. I have this one gained up. Closed captioning is on. Let's move that up here. And let's listen into the last bit of the exchange from yesterday in court.
So whatever you're giving me, I'm not putting in the court file. You're going to have to separately file with the clerk what you're giving me.
Yeah, I will.
Now, has the defense seen what you're giving me?
Yes.
Judge, I don't have an extra copy right now because I wrote on this one. I need my notes.
Okay, well. Natalie,
I can email you one.
can you make a copy of the, Natalie's just going to make a copy of the Excel spreadsheet and she'll get it to me in a couple more minutes.
Yeah, I gave two up there, Judge. Okay.
You're on it. Mr. Whitney, you're next.
And I'm gonna bug out. So you looking
Um,
at me to disbelief.
you might want to hang for just another moment.
All right.
Mr. Whitney.
Yes, Your Honor. If I could just comment on what Mr. Anderson just delivered to you. I won't go into detail. My question is, at this point, we have been delivered some documents regarding this Joint Commission issue. We have not been provided all of the documents that would exist, including the critical September 2018 immediate jeopardy report, audit, finding, however you want to classify that. So the question to the court is, recognizing it's Thursday at 11 a.m., how would the court like us to address this issue if we believe that there are insufficient documents being provided?
I was going to read what's been provided. Was the CMS notification 13119, the CMS survey 11119, the final accreditation report 81418 to 81718, get some done recommendations 62619, and the CMS revisit survey 22119 final.
I didn't hear the self-report in there. I mean, here is, and I want to be very clear about this.
Okay.
I am interpreting my instruction to turn over stuff very broadly.
Okay.
Very very broadly.
Okay,
If there is a scintilla of odor, it needs to be turned over.
okay,
And when I say scintilla of odor, anything having to do with the run up to this report, all self-reports, any prior surveys by the Joint Commission / CMS, because I heard that Mr. Hunter say yesterday, well, there was a prior triannual survey that we passed with flying colors.
So the reason I pulled that notice of deposition up, the plaintiff has made clear what documents they contend are relevant, what they want to see. They referenced scintilla, they referenced reports, self-reports, surveys, and they used the phrase run up. Do you think the judge might have, this is essentially suggesting what the plaintiffs have described, you must produce. This is an indication to defense counsel. I have read their notice of deposition. I have seen the attachment. If you're coming into this courtroom on Monday, and I learned that you are using those words and trying to play games with what is not being disclosed, I'm going to be very upset. So I had rewatched this and I had caught the different references to scintilla, run up, self-report, surveys, and the judge is going very broad. All of the illustrators, the judge is making his point. Nope. If you think you are going to withhold this based on some contention that it's not relevant or it's not specifically identified, you better remove yourself from that illusion immediately. So I think the judge is leaning a specific way, and I think the defense has only themselves to blame for that.
you want that, how far back do you want to go, Judge? Because
Well, let me ask this, and maybe you don't know this.
I might not.
Did anyone lose their job over this issue? Like, is this when the hospital president
My understanding
no longer
is
became hospital
because
president?
of the heart issue that there was some, yes, I vaguely understand. Keep that with a grain of salt. I vaguely understand that as a result of the heart issue, there was a cleaning of house, so to speak.
Well, yesterday, Mr. Whitney said that the documents say that it was not confined to the Heart Institute and that it was systemic. Now, obviously, I'm not in a fact-finding position at this moment, but
Yeah.
I need to at least assume the possibility that the reports are going to show more systemic than just heart-related. I mean, that's, I think, what the plaintiffs are telling me that the media accounts are.
I
that
understand
it's-
that's the allegation, Judge.
Okay, so knowing that I'm not making a finding of fact, but it sounds like there's an allegation and perhaps the media also have made statements that it's not just the heart. I don't know.
Just saying.
This thing just kind of got dropped on me yesterday.
And all of this,
But-
these events are taking place after the events in this lawsuit.
Well,
Okay.
I'm about ready to get there.
Okay.
Because it does sound like the chief executive lost his or her job over this.
I believe that's accurate.
And so when did this chief executive start being the chief executive? Is this when,
Start being the chief executive?
yeah, is this when Johns Hopkins took over All Children's Hospital?
I don't know the answers to these, but I'll take the notes.
Because if we're talking about something that is systemic, something that becomes pervasive and systemic doesn't happen just overnight. It's a culture that is created. And so is it when this president came in, is it when Johns Hopkins took over the All Children's Hospital? Is that when the systemic problem started?
Judge, my understanding is that I forget the acronym of the organization that,
Joint Commission?
thank you, Joint Commission, that the Joint Commission report I mean, they're looking for the documents, but that the Joint Commission report that was done in 2018 that they passed, and it was after that that the hospital self-reported the issues with the heart stuff.
Well, let me ask you this. Was there media accounts that predated the hospital's self-report?
I don't know
Yes.
the answer to that.
Meaning, in other words, did the media bring this to the attention and then the hospital self-reported?
I don't know the answer to that.
But in my mind, if this is an issue of systemic hospital problems, and again, I don't know, I haven't seen any of the reports, and all I'm going on is what I'm hearing in court. But if there is,
Oh no, it cut off. Why did that cut off? Hang on. Tampa 13. Are you kidding me right now? Are you kidding me? Give me one sec. I pulled that because I don't like doing law and crime. But why did you cut that video short? Come on. See if I can't find the same place there. Hang on. Gotta find my place. All right, hang on. We're back. We're back in business. We're back in the business of watching Judge Carroll.
someone lose their job over this issue? Like, is this
Oh.
when the hospital president
My understanding
no longer
is
became hospital
because
president?
of the heart issue that there was some, yes, I vaguely understand. Keep that with a grain of salt. I vaguely understand that as a result of the heart issue, there was a cleaning of house, so to speak.
Well, yesterday, Mr. Whitney said that the documents say that it was not confined to the Heart Institute and that it was systemic. Now, obviously, I'm not in a fact-finding position at this
Okay, we
moment.
gotta fast forward a little bit.
I need her job over this.
I believe that's accurate.
And so when did this chief executive start being the chief executive? Is this when,
Start being the chief executive?
yeah, is this when Johns Hopkins took over All Children's Hospital?
I don't know the answers to these, but I'll take the notes.
Because if we're talking about something that is systemic, something that becomes pervasive and systemic doesn't happen just overnight. It's a culture that is created. And so is it when this president came in? Is it when Johns Hopkins took over the All Children's Hospital? Is that when the systemic problem started?
Judge, my understanding is that I forget the acronym of the organization that,
Joint Commission?
thank you, Joint Commission, that the Joint Commission report, I mean, they're looking for the documents, but that the Joint Commission report that was done in 2018 that they passed, and it was after that that the hospital self-reported the issues with the heart stuff.
Well, let me ask you this. Was there media accounts that predated the hospital's self-report?
I don't know the answer to that.
Meaning, in other words, did the media bring this to the attention and then the hospital self-reported?
I don't know the answer to that.
But in my mind, if this is an issue of systemic hospital problems, and again, I don't know, I haven't seen any of the reports, and all I'm going on is what I'm hearing in court. But if there is a systemic problem, if this president lost his or her job because of this issue, I kind of want to know when that president became the president. Because if we're talking about a creating of a culture, the inquiry, does the creation, or does it start with that president? I don't know.
I don't know, Judge. I think that this is sort of going off the rails a little bit. I mean, the issue in this court for this jury is about whether or not, as I understand it, when the testimony was given, that this hospital passed the, I'm sorry, the name keeps escaping me, the,
Joint
well,
Commission.
thank you. My God, I'll write it down. When this hospital, when there was testimony that they were accredited by the Joint Commission. And then there was an issue raised by the plaintiff, but that ain't true. They in fact were on this double secret probation or whatever. And so that's what started this, Judge. And so now it's become a deep dive into years and years of this hospital.
Well, I
And
think
so
what started
if the
is
Joint
when
Commission,
I think what started is when the defense presented evidence before this jury that says that the Joint Commission had blessed
well,
Johns Hopkins All Children's Hospital, giving what possibly is a very false impression.
well, Judge, so that's.
And not just the Joint Commission,
that's-
also.
Okay. So for those of you who came over from the behavioral arts and interested in body language, can you tell me what the judge's body language is saying right there? There's a whole lot of illustrators, and he's very focused and intent on making sure that he is being abundantly clear about where he is placing the blame for this particular snafu. And it's on the defense for eliciting testimony that if what the plaintiff is contending is true, is remarkably misleading to the jury and has the possibility, well, I'm gonna go ahead and say the all-out likelihood of throwing a wrench in this case right before it gets handed over to that jury to make a decision. And the judge is clear in how he perceives it as being a hospital self-inflicted wound that got called out by the plaintiffs in rebuttal. So that's my read so far. I want to make a comment also for those of you who are sending super chats to donate to Ian's charity, or the charity for the Stollery Children's Hospital. Please consider hitting the link in the top of the chat. While I am giving everything that this channel makes, YouTube takes 30% off the top. If you click the link in the chat and go and donate in that donation box, YouTube doesn't get a cut of it. So please consider doing that. I'm doing the super chat thing because it's a matter of convenience, and it's a way for me to take this stream and use the monetization from the stream to forward that goal. But ultimately, if you guys are contributing to it, I would very much rather you guys do that in that little donation link so that we can also monitor the progress he's making as he works towards that goal of 50K. Okay. So link top of the description, or top of the chat, or in the description of the video.
The federal agencies.
So that's the issue. So if in fact the Joint Commission in 2018, which would go back over the years that are involved here,
Thank you
passed
for
the hospital, and then it was only after that that this issue came up with the heart stuff, then we were in fact accredited in 2016, 2017, when this is the thing. So to go back and deep dive into the whole hospital seems a little extreme for the issue that this is addressing.
Well, I just fundamentally.
I can answer a couple of the courts.
Okay.
I feel very strongly at this point that a deep dive is not only necessary, but is required, and I'm directing it.
Okay, so I don't,
It has to happen immediately.
I understand. I'm just not clear what the court is asking for with respect to time frame and also what documents.
Well, again, I'm asking
Can I get?
when did this president become president? I don't know the answer to that. But if we're talking about something systemic that was a culture that was pervasive through the hospital, then I need to know how long senior leadership was involved. Because if we're talking about the creation of culture, it generally starts from the top down. Now, sometimes it's bottom up, but that seems to be something that I need to know.
But isn't the first threshold question, was it systemic? Before we have to dive deep 20
How's
years
he
or
gonna make
however
that
many years
decision?
this guy was president?
Well,
Isn't
how am I
that
going to
the
make
first
that
question?
determination?
I think the reports would make that determination and the deposition on Friday.
And
You're,
I don't have any more hearing time between now and when we walk in on Monday.
Well, I feel like I can't address the court's concern. I do not have the knowledge as to when
I
this
can.
guy became president.
Okay,
I can.
Mr. Whitney, when did this person, well, who are we talking about?
I wonder if this is intentional. Is it interesting that the attorney that's representing the defense at this particular hearing, Ms. Crowell's, is she was not representing the hospital throughout any of this stuff. So she was, I think, Kathy Beatty's personal attorney for a period of time until Kathy Beatty, they consolidated. She ended up jumping in the case way late. So I have no doubt that what she is saying is true. She doesn't have actual knowledge of this stuff. But she's not the one that I would expect to. Mr. Hunter is the one I would expect to have the actual knowledge. And yeah, people in the chat are, and this one's great. Where is it? No. Where is it? Oh no. Someone said, Whitney, I can. Whitney, like me, I know. LOL, Whitney, I can. Whitney's like, pick me. Uh-huh.
About the first time. Who's the president?
Jonathan Ellen. He
Okay.
was brought down from Baltimore after the acquisition.
When was
He
the
was-
acquisition?
The acquisition,
2011.
I believe, was 2011. I might be wrong on the date.
It's 2011.
Okay,
Okay.
so when Johns Hopkins All Children's Hospital took over All Children's Hospital, the fellow who lost his job became the chief of All Children's Hospital. Is that what you're telling me, Mr. Whitney?
Yes, Your Honor, except I can't represent that he immediately became the president at Johns Hopkins All Children's Hospital upon the acquisition. I can only represent that between the time the hospital was acquired by Johns Hopkins and the time that Maya Kowalski was a patient there, he had become the president and was the president during the relevant admission.
So I can find that out, Judge. Obviously,
So why
when
don't
he
we
became
do this?
president.
Whenever that person became president,
2012. 2012.
that's the date range.
And you're looking for the Joint Commission report from that date
And the
forward.
federal agencies, however they interact with each other.
Okay, I'm not trying to be difficult. That's kind of vague, but I'll report it.
I am doing the best I can.
I
Again,
understand.
I am going to take a very broad view of discovery. So if there's any hint that it might be relevant to this concept, it needs to be turned over. I am going to look on very disfavorably if I come in on Monday morning and I get I didn't get this report from 2017 because I didn't use the proper language in my discussions. Because
I'm hearing the court, Judge, and I'll do my best to articulate this as described.
Your Honor, if I can inquire, only because I kind of missed how this became a thing in this trial. Very quickly,
Mr. Altenberg, he's like, hang on, what are we talking about? What happened? What was the testimony? Why are we talking about this commission issue? How did this come up?
does this relate to the punitive damages for false imprisonment and battery? Does it relate to the negligent training? I'm not quite sure I understand why we're doing this. That's all. I just don't know what issue it triggered all of this. I'm just trying to figure out.
Well, what triggered all this is the defense presenting an impression in front of the jury that the Joint Commission has blessed All Children's or Johns Hopkins All Children's Hospital and basically said everything was fine. And that possibly is either a correct statement or a materially false statement.
Okay.
Very materially false statement.
All right, I understand the
Eyebrow flash for emphasis. Yep.
court directives.
Anything else on this issue, or can I?
As long as we have some date certain, time certain today by which we would know something.
Well, I don't know what that means. I think
We've got
that
a deposition tomorrow, right?
I would say that the court's comments have expanded the materials that we thought we were producing. So I need to get that information.
I'm not sure I expanded it. I just was,
Well, we went back in time.
Enforcing it.
So
He didn't
We
expand
have
it.
to
He
have a
just
little
said
bit of
no.
time to go through these documents before we depose them.
I've said what I'm gonna say on it. It's an expansive, given the position we find ourselves in and how this came up. So let's talk about how Monday morning it's going to shake out.
Yes, sir.
Because I also, am I getting a motion to disqualify one juror or two jurors or three
One.
jurors? One juror. And that's going to be filed today.
yes,
I want to first, when we walk in, I want to first address the imminent jeopardy finding issue.
okay,
That's going to be the first thing we're going to do. And any sort of follow-up. My hope is that if there's any further testimony that has to be done, the plaintiffs are ready to bring it.
Yes,
So
sir.
we can end this case, a few minutes after we bring the jury in. The second issue I think we need to address will be the juror issue,
yes.
and whether we do that before or after the
Yeah,
jury,
do it
I don't know.
after.
It just depends on how long it takes us to deal with the first issue.
Understood.
And then the next issue after that would be if there was any sort of remaining jury instruction issue, we'd probably have to address that issue as well. My hope is we won't have anything at that point. Do either side see anything that we also have to address?
So long as the admission of additional exhibits falls within that first category of discussing immediate jeopardy, no.
When you talk about admission of additional exhibits, I mean, is it going to be tied to either the initial jeopardy issue or that one policy that we talked about yesterday? That's what you're talking about?
That's what I'm talking about, Your Honor.
Yeah, because, I'm not seeing this as we're just reopening up discovery or evidence on other issues, because that's not what we're doing.
Understood.
Okay, anything else on
I
that?
don't think so.
Okay, thank you all very much. I will see everybody on Monday, but I'm sure we'll be in communication.
Oh, baby. Well, the judge has made his position on the matter remarkably clear. No, I'm not expanding it. I am just telling you and reinforcing that what the plaintiffs has identified as being relevant for this particular issue is, in my view, relevant for this particular issue. So y'all need to produce the documents. You saw some very upset faces on the defense side. Monday is going to be a knockdown, drag out fight. You have two of the most significant issues that have been presented in this case thus far coming to a head on a day when the judge had intended that the parties would be giving closing arguments. How are they going to resolve this? I imagine the argument on these motions is going to take more than an hour. Children, my brain is the judge is like, kids, behave, comply with discovery. I need this to be done. But the kids are going to kid and the children are going to be children. And I can guarantee you that come Monday, it's going to be pretty fascinating to watch some of the personalities in this case who are personalities going toe to toe. you can imagine that there's going to be some very, very spicy argument. Probably a lot of blame game. Probably a lot of this isn't relevant. Probably a lot of just all of the things are going to be thrown out on Monday. Just get ready for it. I wouldn't be surprised if you saw some yelling from the judge. So we'll see. Aurora W. The judge just pulled the car over. If you don't quit that racket, I'm going to pull this car over. The judge is like, nope, car's pulled over. Give the documents, sit for the depot. Oof. If I am not wanting to be the defense right now. I am not wanting to be the defense. And you know who I want to be even less than defense counsel? I want to be the corporate designee for JHatch. I want to be that person even less. Nope. Do not sign me up for that job. Get me out of that room. Those questions today were probably remarkably painful. And I can imagine that that deposition was probably about as heated as you can see, you can think of between the attorneys that were trying to muddy the waters in the transcript or get information out. My word. So tossed in that mix. And let me do this. Let me play get some of these super chats and we'll go to the jury issue. Okay. Reminds me of Ron getting the howler on Harry Potter. Yep. That's pretty accurate. Cachette, thanks, Jules, for giving Recovery Act Stream eyes in the court. Thank you, Jules. Tammy Shea for Ian. As a reminder, please click if you're going to donate for Ian, please try to click the link in the chat, donate directly so that we can watch that number tick up. Right now, where are we? Oh, right now, look at that. I think, what did I say we were at the beginning of the stream? We're now up to 8,738 for Ian's charity stream. I would love to see if we can get to 10,000 by the time he starts. I think that would make his day feel a lot better and that 24 hours move a lot quicker. So, Elizabeth, is this a case of bad client, lawyer messed up, or both? Combination. I'm going to say both. I'm definitely going to say both. Heather, Rob, what happens if they find out there was systemic failure and the testimony was false? Then they get to produce that information to the jury. And whatever you thought about how the jury was going to decide, I can't think of anything that would be more persuasive to a jury in this particular issue revolving around the hospital's treatment and care of Maya Kowalski in the context of a medical malpractice case than the hospital saying, oh no, we were fine and we were signed off. And then that being made out clear to the jury as a material misstatement. And that the hospital was in control of that testimony. I mean, yeah. Light Queen, how does the defense counsel not know anything at all about this? It seems very suspect to me. She wasn't counsel of the hospital. She wasn't. So she ended up being brought in very late. Creed M, I didn't see this. Defense filed a 170-page sealed motion to clarify. Fascinating. Fascinating indeed. Tammy Shea, thank you for Ian. Thank you very much. Esme, I expect a lot of objections on Monday. Absolutely. The judge, Alan Fortenberry, says, the judge, you either lied to the court's face or you didn't, and I want to make damn sure which one it is before this is over. I agree. Kaylee, what's your over-under on juror dismissal? I'll get there in a second. Matrix, oh, I'm so confused as to why you're asking this. You mean you have to prove something? Q. Judge, honestly, what you're asking isn't important. Kind of felt that way. Cora Savage, thank you for the very, very, very generous super chat. I will make sure to pass that along. We'll donate to Ian directly, but wanted to say thank you for covering the Maya trial. I couldn't watch most of it because I hadn't realized how much just being a sick kid in a hospital affected me until now. Thank you for covering this and being so sensitive to the many issues. It means a lot. Cora Savage, your comment means a heck of a lot to me. Thank you for being here, and thank you for that encouragement. Samantha Kirkwood, hey, Rob, just after 1 a.m. here in Scotland, but I had to send some love before I head to bed. I'm part of the replay crew. Love your videos. Thank you. Thank you very much. For the kids, can we go back to Witness Anderson's testimony day because Whitney asks for the report then before cross? I saw that. Go back. You can go and follow that on either Tampa 13 or Law and Crime. I'm not going to pull that up now because I have a lot of material to cover. Midnight Muse, I missed the rocket launch today to watch FNF for Ian and the kids. Thank you, Midnight Muse. That's very kind of you. Mrs. Coach K, flipping between this and my husband's basketball game, so mostly replay crew, but wanted to say thank you for Ian. Thank you, Ian and Rob, for paying it forward. I love when he does this stream. It's one of my favorite. Solo Yellow, did she just say double secret probation? She did. Melanie Hideki, these reports are like an onion. Got to go through them layer by layer to get to systemic cause. Yeah, there's a whole lot to peel through in this particular issue. The real Sarah, there you go. Here's what you can look at. So the real Sarah is pointing you to that question. Check right before witness Anderson's testimony when Hunter was out. Part 41. So this is for those of you who are curious. Part 41 in Recovery Addict's stream, hour 2, minute 5:00. Sounds like he was gone on purpose. Oh no, Hunter was out that day because Hunter was, I think, getting back treatment. I think that came out later. Equality, this lady playing all ignorant. I don't know what you mean. I don't understand. It's so annoying. And Hunter Shapiro aren't there for a reason. Nip Pearl Girl, my 5-year-old daughter's recovering from major hip surgery. She had surgery at the Stollery. Slow recovery, the Stollery. Heart the Stollery, heart Ian for raising money. I agree. LA, what if they just don't send the incriminating emails and docs? How would anyone know? Is it an honor system? It appears there aren't consequences for withholding evidence or even for perjury, i.e. AH. There's enough where if a document cross-references another document and that other document that's cross-referenced isn't produced, then that gives them the ammunition to go into court and say, we don't have everything. And it's too big of a risk. It's too big of a risk. Nora Stevens, can I assume, due to the visibility and seriousness of the issue, J Hatch wouldn't try to hide anything with this order without risking their law licenses, whatever else? Happy Friday, Rob. I can see serious sanctions if there's games being played on withholding information or not. I can see serious sanctions. Elizabeth Chetwood worked for a hospital system in admin. Want to see a bunch of uptight executive officers? Tell them Joint Commission is on the premises. I don't have a doubt to that at all. Marisma, thank you for Maya trial 6-month anniversary on my birthday month. Happy birthday to you. And 6-month anniversary of being a member of this channel. Destiny Salazar, really feel for this judge. He's been dodging landmines the entire trial. He's kept the jury from as much drama as possible. I agree. I completely agree. JM, how do I find a Connecticut lawyer like Mr. Whitney? Please speak with people who have been represented by counsel. They will try to point you in their way. There's no better referral than a friend who's been represented. So communicate. Killer Stink, for a fellow extra lifer, this will be my 7th year and first year trying to stream it. Cheers to you, my friend. I wish you all of the best, and I hope that stream goes well, and I hope that you raise to your goal. Robin Day, as someone who needed a children's hospital, this is for Ian. Yep. Tamara Cartwright, this one requires explanation. We know where the Mexican went. This is in reference to the coin that Spidey was using for a magic trick that he showed me before I was able to jump off. Valerie Storm, Rob, it's my birthday, and a cheers would mean a lot. Valerie Storm, happy birthday to you. As a matter of fact, happy birthday to all of the November birthdays. Cheers to you. May you have a blessed next year. Happy birthday indeed. Valerie Storm, happy birthday. Make the most of this weekend. Amber H, will you cover the Spicy Cross from Tuesday? I did on my recap stream from earlier this week. Early Annie, Rob show Veritas's minis to Ian for auction. Interesting. I will try to do that. Summer Golden, my husband has a very high stress job with a Fortune 200 company. He was their corporate representative testifying in a lawsuit not long ago in Virginia. He came home telling me the immense amount of respect he now has for lawyers. Cheers to FNF. Yes. Yes. In these depositions, the lawyers have almost everything. My dad sat as a corporate designee for Bechtel a while back in a lawsuit or an arbitration. And I remember that Bechtel's lawyers sent prep binders to my house because my dad was staying with me at the time. They delivered by courier 2 6-inch binders that had basically every email communication between all the different parties. And my dad was parsing through it and he goes, oh my God, they have everything. Now Bechtel ended up winning and prevailing in that arbitration. So dad did great in that designee role. But they have the opportunity to look through those documents. Don't think they're not going to find something. Tracy Curtis, here's to the future. Thank you very much. Courtney Michelle, I drove from NJ to DC with all my windows open today. It was gorgeous. 13 more hours till I get to Florida. Safe drive. Lindsay drinking lemonade and trying to talk myself out of ordering in for dinner while I listen to my upstairs neighbor throw a hissy fit over some sports ball thing or another. Well, best of luck to you, Lindsay. Matt Bond, did you ever know that you're my hero? I'm supposed to sing that. Did you ever know that you're my hero? Okay. Braxton Heaps, I sent you an email bit back about the spinning wheel of death. I've been having the same problem and may have found a solution. If you're interested, Braxton, I will check that out. My email has been, as you guys can imagine, every time I mention something on a recap stream, there's a backlog of emails that I have not gotten to. I promise you, I will hope to get to those and start sifting through some of that stuff. I have to get back to a lot of people about a lot of things. In love with the law. Love this channel. Just purchased my membership. Thank you for doing that. And thanks for becoming a member. Pam Bystrak tuning in from Sykesville, Maryland, spinning some wool yarn while watching, drinking Diet Coke. Thank you for being here. Lois, just Lois, or Louise, just Louise. What a community. Big hearts to all who have gifted memberships. Big hearts indeed. Elf Liggins, hooray to see Rob stream for my birthday. Happy birthday, Elf Liggins. Cheers to you. Good luck to Runkle tomorrow. I'll be celebrating by watching and randomly donating. Perfect way to celebrate. Midnight L 2008, ready for a fun night after surviving teaching first grade all week while dealing with bad sinus infection. Oh my gosh. I hope that thing clears up. Those are really, that's brutal. I hope you feel better. Mayor Lynch, is the Mexican coin in your pocket? I don't think so. He made it disappear on stream. Emily Aarons, longtime lurker, first time chatter. Happy Friday. Happy Friday to you. Thank you for chatting. Thank you for engaging in the chat. Matt Bond, hello, my spiffy legal mumbo jumbo talkie brother from another mother. You totally rock, dude. Thank you, sir. Very much appreciated. Hollister 74, my last day working at my first school. I start my new job at the new school on Monday. Today was tough. I need F&F tonight to ease my heart, saying goodbye to my kids. Never easy, but I hope that new job is has a lot of good and happy moments for you on the horizon. I would very much like to see that. Terry McLean, does it matter that the last Joint Commission report was fine? I believe they got in trouble after the regular exam. We are going to see. There's a whole lot that we've been trying to uncover that we just don't have information on yet. Nanner, chat, YouTube takes a large percentage. Use the link. Yes, please do. YouTube takes 30%. Please use the link. Please use the link. It's in the chat, top of the chat, pinned comment. It should be right there. Braxton, thank you. I'll reply to the email so it's at the top. Thank you very much. Marmar, it's daylight savings this weekend. Does Ian know? I don't know. I'll tell him. I will. So let's do this. Sardinisms. Seconding, Cora, never realized how badly a childhood of doc, go round, and medication messed with me until this trial. Can't watch much, only yours. Thank you. That means a whole lot to me that you guys tune in to watch this stuff, because I really try to be very, very careful in how I approach the testimony, the evidence, and the arguments being made, because I know that it is a sensitive issue. I very much know it's a sensitive issue. All right. I want to do this real quick because I need 1 second. So we're going to, I don't mean to say self-promote for a second, but I need a minute. And this is a good segue to get us to talk about the jury question. And that I like. So just to give me a minute, by time, let's go ahead and see Recovery Addict freak out.
Member for 9 months, so they can't believe. Okay, stop. I need the Southern Febreze.
Hey, can somebody bring me the raid?
There's a bug. There's a bug in my studio, and I don't want to turn the camera on it because I'd have to zoom out so it would all fit in the camera lens. It just went behind the cabinet. It's you guys. Oh my goodness. This I will tell you what's going to happen. What's going to happen is this. That bug, and when I talk about bug, I'm talking, it's those, they call them water bugs here in the South. We know what they are, and they're not water bugs. That was like, it was the size of a small dog. And occasionally when we get one of these that come inside from outside, and usually when the leaves, when they fall down, they're around the leaves outside. But when they get into the house, I have words to say. And now it's literally, it's crawling towards my green screen. So I'm going to be on camera like this, and then on the green screen, you're going to see a bug crawl across the wall. That's what's going to happen. And it will be mortifying. It will be so bad. My family is ignoring me. They're playing the tuba in the other room, but nobody's bringing me the Southern Febreze, which is also known as Raid. You can get it in all different scents. But let's see. You guys, we might have to stop the show. It was right there. It was like within arm's reach. Oh my goodness. We need an indoor cat that eats bugs. Okay. Oh my goodness. Get the raid. You guys, this is literally, I have a couple fears in life. And one of them is definitely having one of these bugs make it into the house and crawl across my green screen. It might be irrational. It might never happen. But if it does happen, I will never live it down. And that bug literally is like 4 feet from my green screen, and it was headed that direction. I need you guys to keep an eye out for it. I need you guys to watch for it. Oh my goodness. I need the raid. We need the raid. This is bad, guys. It's gonna be a bad day. I can't step on it because it was like at waist level
this is
on the
never
wall.
gonna get old for me.
And my feet don't go that high. All right, so Southern Febreze is ready. Here we have not sponsored by the way. This is it looks like this is lavender scent, Southern Febreze. We're gonna put that right where I normally keep my drink and make sure I don't confuse the two. But I'm gonna be looking like this until I find the thing. Oh, it's up high. It's literally
on your head.
Don't you dare. Okay, here's what we're gonna do. I'm sorry. Usually we're a little more professional in the mornings than this. We're gonna get. I can see it. It's above me, almost straight up. We have 11-foot ceilings in this house. It's an old house, right? We have 11-foot ceilings, and there's a picture rail that runs around about 10 inches down off the ceiling, and it's between the picture rail and the ceiling.
This is never
It's
getting old.
It is almost straight above me. And when you spray a bug that high above you, I've learned from experience, they fall, they fly, and they aim for your eyes. This is how. Angie, please, nobody clip this. I don't want to see this on Twitter.
Sorry.
Or anywhere else. If this appears on my green screen, it fell. It's so help me, you guys. Okay. It could be anywhere. It's now halfway. It's 2 feet from my green screen. It's now on the ledge that hangs over the top of the bookshelf. I've got 8-foot bookshelves in here, and it's on the top ledge, which hangs over my desk. I can touch the bookshelf. I'm not going to right now because there's a bug on it somewhere. And the fact is, I have to stand up. To
Musical
get this.
notes, happy
And it's
day.
No Pants Friday, so
Cockroach.
I've got all sorts of issues going on that are presenting problems. Can't go anywhere. You have to. Did you see it? All right, let the cat in. Will cats eat these? Bug will be dead by the end of this show for sure. Bug has nowhere else to go. I mean, it's not like there are wires that can hide behind here. Yes, cats will eat them. We're keeping the cat.
Okay. Thank you for bearing with me for a moment. That's just too much fun. So I liked when he said, "Don't clip this," which immediately told me, "Rob, clip this. You need to clip this." Like best hour I ever spent trimming that down. A lot of fun. Anyways, so moving on from that, thank you guys for your patience, allowing me to go ahead and do that. Let me pull up the next document I need to get to so we can discuss this. And so we heard reference to a motion to disqualify, and some of you might have laughed at me for saying yeet in the video description. I've always wanted to say motion to yeet. So we have a motion to, for all intents and purposes, yeet one of the jurors. So defendant J. Hatch, by and through undersigned counsel, moves this court for an order disqualifying juror number 1 from serving on the jury, which deliberates to decide the above styled cause. For those of you who are curious, we also have the plaintiff's response to said motion that I'll be covering next. So defendant submits that juror number 1 on multiple occasions and through multiple questions and statements communicated to the court in connection with questions has revealed 1, a bias or prejudice in favor of plaintiffs against the defendant, and 2, a violation of this court's instructions to the jury not to form or express any opinion about the case until retiring to the jury room to consider a verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. In support thereof, the movement J. Hatch states as follows. Throughout the trial of this cause, the jury duly sworn to hear this case, along with the alternates selected, appear to have paid diligent attention, and their attention has been reflected in a substantial number of juror questions. In the process of posing such questions, however, one juror, identified as juror number 1 in his questions, has repeatedly revealed not only a substantial bias and prejudice in favor of plaintiffs and against defendant, but also a violation of this court's instructions, as set forth in Florida Standard Jury Instruction 1.1, that he or she, quote, should not form or express any opinion about the case until you have retired to the jury room to consider your verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. Okay. First question for all of you lovely folks. I want my tools. Where am I? Give me the toolbar. I want my highlighter. Where's my highlighter? Add comments. That's in there. There's the highlight. Let's go ahead and I want that added. But it says it's added. It says it's there. Liar. All right. No highlighter. I want the highlighter. Okay. Either way. Proceeding forward, juror number 1's statements evidencing the above include, but are not limited to, the following. Most recently, in questioning Nurse Sylvia Ballweg, a witness called by the defendant, the juror prefaced the question by making a statement to the effect that the witness was a breath of fresh air, or words to that effect. Well, here's the thing. If you're going to throw it in quotes, you don't get to say or words to that effect, since she was the first person from the defendant who appeared to have cared about Maya Kowalski. In a question, defense witness Carrie Thatcher, APRN, juror number 1, asserted that his ethnic background was the same as the decedent, Beata Kowalski, mom, with the result that both the juror and the decedent tended to be, quote, pushy. Juror number 1 stated specifically that he identified with the decedent and questioned whether the witness had overreacted to the decedent, suggesting a belief that she had done so due to the decedent's ethnicity. Chat, you win. Chat, you win. Aha. Oh, thank you, Faith. Thank you. Now we have buttons. There we go. That's much better, right? Much better. Ask question when an early witness stating there, quote, appears to be probable cause of improper action by/of Sally Smith in her assigned role for J. Hatch, thus indicating that the juror had formed and was expressing an opinion regarding the case and the evidence in violation of the court's instructions and indicating a predilection against the defendant. Are you seeing a bit of a trend here? Are you seeing a bit of a trend? Because I started seeing a trend here. One, I'm going, well, the plaintiff or the defense appears to be very good at reading the minds of other people based on limited words and interactions. So they seem very good at reading minds. 2, we are getting a lot of things that appear to be quotes that are taken out of context from the full question and then interpreting those quotes. So a lot of this is kind of superimposing, or you could say projecting what they are perceiving onto this particular juror. Juror number 1 expressed an opinion in prefacing the question of witnesses indicating an understanding CRPS can come and go, get worse, or reside disappear, thus reflecting not only an opinion about certain matters in the issue, but acceptance of plaintiff's evidence before he heard the defendants. Well, let's go ahead and break this one down because this one gets thrown under the bus in a second. Understanding CRPS can come and go, get worse, or reside / disappear. You mean that the witness, having heard prior testimony from another witness, is using that to inform the ongoing opinion that may or may not be forming. Not formed, forming. This to me indicates analytical thinking. So right here, you are saying to this new witness from J. Hatch, how am I to take what was said by the previous witness and reconcile that with what you're telling me now? That's what that is. So at this point in time, in reading this motion, I started questioning the motion itself. Questioning various witnesses called by the defense, including Charlotte Laporte, in an adversarial manner, confronting her with questions regarding whether she can, beyond doubt, affirm that, or whether she was, quote, able to attest to matters she addressed in her testimony, specifically those related to Catherine Beatty and telephone calls. And again, indicating an adversarial predilection against said testimony in favor of the plaintiffs. Well, that's reading a whole lot into it, because these seem to be keywords that the witnesses had heard from various other witnesses, or from the jury that heard from various other witnesses. I have no doubt. I can affirm, I can attest. These are just keywords that are being discussed again. Questioning witness, including Miss Tori Nyhus, I'm going to screw that name up every time, as to whether her team or the hospital possessed certain photographic or video evidence. By posing this question long before testimony had been concluded or argument submitted, the jurors indicated that a burden had been placed on the defendant above and beyond any contemplated by the court. That is the very definition of projection. I'm a juror. I am seeing plaintiff's witnesses present information. If the witness is being called by the plaintiff, I am very much thinking that's the plaintiff's witness. I can see them being on a team. I can see a person that's watching this take place, understanding that or reaching that possible, viewpoint. Conversely, if a witness is being called by the defense, I can see the person saying, well, this is on the defense team. There's teams. These are individuals that are not trained attorneys. Not only this, but these questions, notice we're not getting the full questions, just parts of them. In questioning Ms. Laporte, the juror in question began with oh gosh, man. How many times can we throw a question in one sentence? In questioning Ms. Laporte, the juror in question began a question with representation that plaintiffs had provided address for Maya Kowalski to the defendant or Ms. Beatty, indicating a prejudgment of the evidence with respect to that issue. Is it though? And without having heard all the evidence pursuant to the court's instruction. In the same question set, the juror in question confronted Ms. Laporte with questions. Oh my gosh. Stop. Questions. In the same question set, the juror in question confronted Ms. Laporte with questions regarding whether she knew the address in question resided in Ms. Beatty's office, and or whether the witness knew it was not timely given to Maya Kowalski, indicating an acceptance of plaintiff's evidence before having heard all of the same. Is it though? Is it? Because again, we see one little quote here, one little quote here, and a lot of interpretation of what that's supposed to mean. Questioning at least one witness with the preface that plaintiff Maya Kowalski was, quote, more mature than usual for a 10-year-old and or handled her pain differently, thus expressing opinions that reflect acceptance of plaintiff's evidence and testimony, except for the fact that even witnesses that you had called, J. Hatch, had expressed that Maya Kowalski had a more advanced maturity. So that doubles back on itself. Questioning witness Stephanie Graham in an adversarial manner regarding statistics related to the success of her case ratio, and also regarding her interrogation of plaintiff Jack Kowalski, but despite the witness's own testimony that discussion in question with Mr. Kowalski was an interview. Well, that just indicates that maybe the juror didn't believe what was being testified to. And now you are asking me to place myself in the mind of the jury and see the evidence in your way rather than theirs. The jurors have the absolute ability to question the motivations, the credibility, and the trustworthiness of the witnesses that are testifying. So this one, you are starting to lose me. You are really losing me in this motion. Questioning witness Richard Elliott in a sarcastic and biased manner, indicating an opinion regarding the subject of his testimony, billing. Really? I don't see a footnote or a citation or a quote to the question that you found objectionable. Questioning witness Billy Seisel after a preface referring to him as a newbie, indicating a bias against the credibility. Questioning Billy Seisel after prefacing the same with, quote, is it possible that Maya's waning abilities could be contributed to J. Hatch causing the limiting family interactions, the stress and trauma Maya has testified to, document statements by Maya about mother status, told by hospital staff, Miss Beatty, etc. That looks like the jury is inquiring. That looks like a juror who has not made up their mind, but is asking further. Please clarify these different points. Questioning Sally Smith by referencing plaintiff's testimony regarding the length of time that it purportedly took the hospital staff to respond to telephone calls. Referencing plaintiff's testimony. That sounds like investigation in the process of forming an opinion, not that the opinion was already formed. I have told you, when the jury is questioning these witnesses, after every question, I think I have made the comment, well, this is giving you an indication as to what the jury is thinking. Thinking. Not a predisposition. What they're thinking. How they are viewing the evidence as it's being presented. Whether they are perceiving one side more skeptically than the other based on the collective evidence that they are receiving. That's completely allowed. That's not bias. That's not bias in the slightest. During the same sequence of questions to witness Sally Smith implying that the hospital itself was guilty of child abuse, the questions indicate an obvious bias in favor of plaintiffs and against the defendant, and again suggest a violation of this court's instruction as outlined above. So, a party seeking to remove a juror for improper behavior in the course of trial must show that the juror's actions amount to misconduct. Okay, so that's a pretty high burden. You basically have to say, if I'm trying to remove a juror for improper behavior, I have to show that that actions by that juror is misconduct. So the trial court must excuse a juror where there's reasonable doubt as to whether the juror is impartial. Reasonable doubt shall be resolved in favor of the excusing the juror. Bias need not be demonstrated with unmistakable clarity, but you have to demonstrate it. That's my problem. Bias doesn't need to be demonstrated with unmistakable clarity, but you have to demonstrate it. If what you are saying demonstrates bias is that a question might appear more pointed, more adversarial at this stage when you are presenting your case in chief, if what you are saying is that that indicates bias, I completely disagree. I want an intelligent and questioning jury. if they start to form skepticism towards what they're perceiving in testimony from the defense, they're allowed to have that skepticism. That's the provenance of the jury. While a trial court is afforded great discretion in ruling on challenges of jurors for cause, close cases involving challenges to impartial or of potential jurors should be resolved in favor of excusing the juror rather than having doubt as to impartiality. None of the questions have given me doubt as to whether this juror can perceive information in an impartial fashion. Did the juror say, seems to me like you're lying? Or did the juror say, clearly you're lying because the plaintiffs are true? No, they're viewing evidence in the context of prior evidence. That's natural. This is a poison pill motion. This motion is a poison pill. This is a motion that is supposed to highlight to an appellate court, look what the judge failed to do. This juror is totally biased against us. And let me point to the questions. Oh, nope, never mind. Not the questions themselves, but I'll point to little specific line quotes and then give you my interpretation of what that question was intended to convey. I'm going to put myself in the mind of the juror and go ahead and say this is what the juror meant. As set forth herein, the standard for juror misconduct is satisfied in light of juror one's apparent prejudice and bias revealed through the course of trial through his questions and demeanor. Was it though? And even if there were any doubt regarding juror number one's bias in favor of the plaintiffs, and there is not, that doubt must be resolved in favor of the disqualification under Florida law. If I am the judge, I'm going to go ahead and use that language in my order. And even if there was any doubt, oh, dang it. Even if there was any doubt regarding juror number one's bias in favor of the plaintiffs, and there is not. You're right. There is not. There is not a doubt. Because the absence of a doubt is that he's not biased. That you have not demonstrated to me that there is bias. You have demonstrated skepticism. You have demonstrated analytical thinking. You have highlighted to me the role of the jury. As a practical matter, moreover, obvious bias on the part of a juror risks a hung jury if other jurors believe the juror in question has violated his oath. Well, that's a stretch. I'm not sure how you got there. Now we're at the violation of an oath. Finally, no party will be prejudiced by removing juror number one, given that an ample number of alternatives have been chosen, and the alternatives in question appear to have been every bit as attentive as the primary jurors. Well, this sounds like you're messing with the jury process. This sounds like, you don't like what the juror was saying, or the questions being asked by the juror in the process of that juror forming his or her opinion. The thing is, they use this idea that the juror has formed an opinion already. Now, what is that supposed to mean? Forming an opinion. You shall not form an opinion. You shall not immediately discredit or just opine that this person is not to be considered. I don't want you to hear anymore. That's what it is. I don't need to hear anymore. I have formed an opinion. This is my opinion. It's there. It's rock solid. I don't need to hear anymore. The fact that the juror is asking questions at all indicates that he or she has not yet formed an opinion. The questions at all means I am looking for answers to these particular questions because I am in the process of forming an opinion and I would like to have your input on that opinion. If I give you a statement that might be viewed as additional skepticism towards a position that you just relayed to me in testimony, I am giving you the opportunity via my question to refute that observation, to explain how I am wrong in making that observation or thinking down these lines. Not only that, I'm giving you the opportunity to refute that openly to the remaining 11 jurors sitting in the box next to me. So here's your shot. I'm viewing it skeptically. Explain it to me. Tell me why I'm wrong. Tell me why my question should be viewed or said a different way. And you have the chance with the 11 other jurors to explain to them, and they might disagree with me entirely. Such procedure has been okay. So hang on. They did so the procedure of swapping an alternate in for the actual delegated juror. In Allberger, for example, a personal injury juror was permitted to ask questions, and as the jury here has. At the close of the evidence, appellee objected to one of the jurors on the grounds that, from the nature and manner of that juror's questions and comments, it was apparent that the juror had shown bias and lack of objectivity, as in this case. Well, there's an accusation. Okay. The trial court substituted an alternate for the juror in question over appellant's objection, and did so without questioning the juror as to whether his comments amounted to a prematurely expressed prejudicial opinion. The district court held there was no error in the trial court doing so or in the manner in which it did so. Well, see, the thing is, the fact that that's not an error doesn't mean that the judge should or needs to do it here. This is driving me nuts. In doing so, the third district noted that any purported error was harmless in that the alternate juror had been chosen, qualified, and presented through the entire proceeding. Okay, that's fine. But that's not what we're talking about here. Although Florida case law is not uniform on whether questioning a juror before disqualification is necessary, Allberger supports the proposition that the act of questioning a juror under the circumstances at issue could reinforce his or her prejudice or bias without cause. I always find it wary when lawyers say this case supports the proposition, because that's a key word you need to kind of focus on. This case supports the proposition. Notice what is omitted from that sentence. What is not said. It does not say this case tells you, this case dictates, this case directs, this court held that this must be done or should be done. No. It says it supports the proposition. Well, what proposition does it support? Oh my gosh, coincidentally, the same one I'm asking you, Judge, to embrace. Instead, why don't we look at the actual language? But again, that's a negative. It's kind of inferring the reverse of what that case told you. In addition, given the extent of juror number one's apparent bias, prejudice, and failure to follow instructions, any questions by this court would serve no useful purpose. Well, here's the thing. Apparent bias, you've explained how you think that exists. Prejudice, you've explained how you think that exists. Failure to follow instructions. You lost me. Any questioning by the court would serve no useful purpose, given that the juror is well beyond any rehabilitation and would risk alienating not only the juror in question, but also other jurors. Dear Judge, do not ask the magic questions. You know what happens if Judge Carroll asks the magic questions? Harm averted. If Judge Carroll goes to juror number one and says, juror number one, I've had some questions about your questions. And given my admonition at the beginning of this trial, when I first instructed you that you were to not form any opinions and please listen to all of the evidence before forming an opinion when you go back to deliberation, that you're not to express those opinions prior to you going back to deliberation, and that you're to receive all of the information and evidence without forming those opinions throughout the trial. forming those opinions. That is a final result. It's not a matter of what is being done throughout the process of forming an opinion. For example, I have been candid and clear with all of you about my opinions and how they have changed. Rather, not my opinions, about how I am navigating the evidence in hopefully forming an opinion towards the end. What I've explained to you guys throughout the way is, I go back to the summary where I gave how I view the case so far. And I use that because that's really important. How I view the case so far. I told you from the very beginning, as we were listening to the plaintiffs present their case, it would be clear that it would appear to you that I would have an opinion more favorable for the plaintiff. And I also told you that as the defense presented their evidence, it would appear to you that my opinion would again sway more in the direction of the defense. That's the natural progression of evidence. The juror has heard one side and now they're hearing the other. And to believe that a juror is not going to view the other side with skepticism from what or trying to sort it in line with the information that they just received. That's ridiculous. That contention is completely ludicrous. You're telling me that if I see someone up on the stand and everything in my gut tells me that this person is a liar, and then I see someone on the stand that follows this person, everything in my gut tells me that this person's being truthful, that I can't look at that prior testimony through the lens of what I just learned from the new witness. That's ridiculous. That would completely destroy the jury system. Are we trying to replace jurors with robots? Where all of the data is being processed in real time simultaneously? No, there's a natural progression to cases. So I'm very frustrated when I see stuff like this, because this seems like a bit of a low blow. And not only that, but it seems like it completely misconstrues what a jury does and what jurors do, all while giving it this nefarious label of something untoward. It's intended to make that juror seem very biased, when yes, that juror has been argumentative with defense witnesses. That is a natural progression of thought process. That's a natural progression of how we analyze information in, keyword, forming an opinion. Forming. Not that it's already been formed, that we have a predisposition or that we have a bias. No, we are exhibiting our thought process as we are reaching the opinion that we are forming throughout the course of the trial. So that was my read of this. Now, let's see what the plaintiffs say in response. Caveat, I haven't read this one yet. Plaintiff's response to defendant Johns Hopkins All Children's Hospital. Motion to disqualify the juror. Plaintiffs oppose defendant J. Hatch's motion to disqualify juror number 1 based on some of the juror's questions. Here's the other thing about this. The other thing about this one is, what if all of this is a red herring? What if we are reading way too much into the mind of this particular juror, and that the juror is asking questions not based on their own thought process, but based on what they would believe the plaintiffs would ask, because they want to hear the answer. But they're hearing the response and answers, and they're putting that in the bucket for the hospital and saying this is favorable to the hospital. You see how dangerous it gets when we start trying to read the mind of the juror based on the questions being asked? I can ask any number of questions and you guys wouldn't be anywhere near the wiser as to what my opinion might be. That is my job. My job is to ask questions and elicit answers that are favorable to my client's position. If I'm not asking questions in a pointed fashion, I'm not doing my job. I'm not getting information in front of the court that I believe the court needs to hear favorable to my client. So we start playing a very dangerous game with the jury system when we start inferring from questions being asked what this juror knows or thinks or biases that are held. And to suggest that we're not going to ask the juror whether they have maintained their oath and they have not yet formed an opinion, to say, judge, do not ask this juror to say yes or no whether they are still capable of viewing the evidence fairly to both parties. No, that is asking for prejudgment. Are you out of your mind? That is asking for prejudgment before this juror has an opportunity to go and express how they are viewing the evidence to that juror's colleagues. People are saying I missed the last part of the motion. Did I miss the last part? Wherefore defendant, let's see. Wherefore defendant Johns Hopkins moves to the court to disqualify juror number 1 for reasons set forth and substituting the first alternate in his place. Okay. Defendant is factually and legally wrong. Love when statements come out strong. If you're going to make the point, make the point. Don't dodge it, make it. Probing questions do not show bias. And the defendant ignores the juror asking questions on both sides. Defendant's tactic, if successful, would promote gamesmanship for parties who want to eliminate a juror during trial and undermine confidence in the judicial system. Thank you. Like I said, I haven't read this, but I kind of thought that this would be the response. Plaintiffs note that the parties have been provided copies of the jurors' questions through the last Thursday. Nevertheless, the defendant chose not to quote the actual questions. Oh, good. They noticed too. Opting instead to describe the questions or quote small phrases out of context. Plaintiffs take issues with these characterizations and with defendant's assertion that these questions show a bias in plaintiff's favor. For example, defendant describes the question in 2E. 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 Scroll. 2E was this one. Charlotte Laporte, beyond doubt, affirm that, unable to test. Okay. So, for example, defendant describes a question 2E showing as juror number 1 question defense witnesses in an adversarial manner by prefacing his question by, so does a guy, by asking if the witness could beyond doubt affirm that or was able to attest to something in the witness's testimony. Far from demonstrating juror number 1 as being adversarial towards the witnesses, it more than likely shows he was only mimicking the lawyers of both parties. Thank you. That he had been listening to for so many weeks. Another example is when defendant complains about juror number 1 prefacing a question by saying Maya was more mature than usual 10-year-old and handled pain very differently. Dr. James Lewis, who conducted, yep, here we go. Oh gosh, you guys, who's reading my brain? Dr. James Lewis, who conducted Maya's psychological evaluation while she was at J Hatch and being investigated by CPT team, described Maya in these terms. Told you, defense witness. Defense witness. The parties do not yet have the exact words of juror number 1's comment and questions to nurse Sylvia Ballweg, in which she stated that she was a breath of fresh air. Defendant's first example. So while plaintiffs agree juror number 1 described this witness as a breath of fresh air, they disagree with the defendant's characterization of what juror number 1 meant by this. Yes, you are inferring and arguing what this phrase, 4 words, breath of fresh air, was intended to mean or convey as giving you insight into that juror's mind. To the best of plaintiff's recollection, juror number 1 did not explain his comment, and he certainly did not say that he thought the witness was the first person from defendant who appeared to have cared about Maya Kowalski, quoting from defendant's motion. One possible interpretation is that juror 1 thought plaintiff's counsel had questioned her too aggressively, and he was simply being encouraging to her. That reasonable people, well, I thought that. I certainly thought that. That reasonable people could interpret this statement differently, however, demonstrates the comment does not show bias in favor of the plaintiffs. Thank you. I can read that question a different way. That's what that's intended to mean. Defendant's motion also omits other questions asked by juror number 1 that were either completely neutral or could be viewed as, quote, revealing bias in favor of the defense against the plaintiffs. For example, so now we're going to get a list of neutral questions or questions that would seem to suggest that they believe defense and not plaintiffs. Juror number 1 asked the defense witness, Jennifer McCain, regarding the complexity of medical issues without any indicia of bias. Dr. McCain, in your testimony, you've used the phrase similar to psychological component. Should I interpret that to mean there is a mental component, but there is also a physical component, or does your phrase psychological component mean there is no physical component? This is a good damn question. That doesn't suggest bias one way or the other. That's a good damn question. They asked Nurse Alsid regarding issues of fact for his determination. Nurse, what color was Maya's court attire that you helped her change into? Okay. Asked defense witness, the same nurse, about the timeline of the events. Nurse, in this timeline, is this timeline in clothing correct? Help Maya down to shorts and white bra? Yes. Photos then taken. You help Maya into dress with same white bra, or you change her bra. That's a clarification of a timeline. And that's allowing the nurse to give the exact same timeline back, which could be favorable to the hospital. Juror number 1 pointed out Nurse Reck's kindness. Nurse Ms. Reck, it was very kind of you to tend to Maya's laundry. My question would be, why didn't the parents of Maya tend to their daughter's laundry? Was the need for you to tend to Maya's laundry because Maya's parents were negligent to their daughter's cleanliness or needs, or was there something restricting their visitation? I can read that both ways. I mean, think about that. Even if I just say it, if I just read it in different inflection in tone, it can be read as being favorable to Maya or favorable to the hospital. Ms. Nurse Reck, it was very kind of you to tend to Maya's laundry. My question would be, why didn't the parents of Maya tend to their daughter's laundry? Was the need for you to tend to her laundry because Maya's parents were negligent to their daughter's cleanliness or needs? Or was there something restricting their visitation? As in what this juror might perceive as being a proper restriction to visitation. You see how that can change based on how you read it? Juror number 1 asked an unbiased question to defense witness, doctor, if during this time Dr. Smith, per Mr. Shapiro, was acting as a DCF employee, then is it proper for Dr. Smith to act as a contributing staff member for JHatch? What is wrong with that question? How many ways could you have phrased that question to suggest bias? Juror number 1 continued to ask unbiased questions to defendant's witness regarding the timeline of events. Dr. Teppa, how long did Maya spend in the ER before being transferred to the PICU unit? When Maya was transferred to the PICU, was the mood of Maya and the parents on a more even and calmer level, or was there still a flurry of confusion? That's a good damn question too. Juror number 1 tried to limit plaintiff's expert witness, Dr. Kirkpatrick, to a simple answer by asking Dr. K, in the simplest terms, is it safe to say? And a simple yes or no will do. See, this, if you're reading defendant's motion and what the defendant is doing in their motion, suggesting that a combative or a preface or something like this would be showing bias, then telling the plaintiff's expert witness, Dr. Kirkpatrick, just a yes or no, doc. That would suggest aggressive, wouldn't it? Plaintiff number 1 sought information related to Maya's alleged CRPS diagnosis, indicating that he had not determined whether she had CRPS or not. All Maya was discharged with 3 to 4 diagnoses by J. Hatch, and none were CRPS, correct? When, if at all, was Maya ever examined and given a diagnosis with CRPS, date, and doctor name? That seems to be a pretty skeptical question towards the witness. Juror number 1 sought guidance on issues related to Detective Graham's interview with Jack Kowalski. His question indicated that he wanted to know the law behind Detective Graham's intentions in her interview and maintained an open mind. Dear Judge, clarification, please. Cameras and reasonable expectation of privacy. What is the law? And in a hospital setting, in a private single occupancy room, is that an expectation of privacy area? I think yes. Please educate me. This is the juror expressing their thought process. Thought process, not their opinion, not what they have formed as their conclusion, how they're thinking about it. Juror number 1 continuously questioned Maya's CRPS diagnosis. After being released from J. Hatch in January of 2016, has Maya ever been re-diagnosed with CRPS, or are those 3 or 4 from J. Hatch are the last? Defendant correctly states that a party seeking to remove a juror for improper conduct during a trial must show the juror's actions amounted to misconduct. Footnote. Juror misconduct may occur in limited ways other than misrepresentation or non-disclosure on voir dire, including inattention to the proceedings, sleeping, misuse of evidence, leaking it, or improper deliberations, talking with your fellow jurors about it. For example, in Powell versus Allstate, set aside a verdict because members of the jury had made numerous racial jokes and statements about plaintiffs who were Black citizens of Jamaican birth. Well, that would get you kicked off a jury. Here's what I was saying before, how they said it stands for the proposition, right? So defendant cites 3 cases standing for this proposition without providing any factual description of the cases or their holdings. The first 2 cases are factually very different from the situation before the court here. The third case, however, Washington v. State, is remarkably similar. Footnote. Oh, the 2nd District cited Washington with approval. Okay, so you there. So Washington held that the trial court abuses its discretion by removing a juror based on purportedly biased questions the juror asked her in the trial. Well, that seems to be a different case. And although defendant cannot be criticized for failing to cite the case, oh, that's shade. That's lawyer shade. I don't fault them for not citing this particular case. It only did so by burying it in a string cite. Gee, I noticed that you left the part out about this particular case. Is that because blank? In Washington, the trial court instructed jurors at the beginning of the trial that they could submit written questions aimed at clarifying the evidence and encouraged them not to ask a large number of questions. During the trial, juror McCoy asked a great many questions. After all the testimony was presented, the trial court announced it was replacing juror McCoy with the alternate because, quote, Ms. McCoy was the only juror that asked any questions. A large majority of these questions asked by her were contrary to my instructions, showed a total lack of understanding of the testimony that had been presented, were generally argumentative and hostile questions. The reconstituted jury ultimately returned a guilty verdict, and the defendant has appealed. The 1st District reversed the judgment based on the trial court's removal of juror McCoy. In an opinion authored by Judge Padovano, the court rejected the state's argument that juror McCoy's questions demonstrated misconduct by revealing bias in favor of the defendant. Well, this is interesting. The court stated juror McCoy appears to have been skeptical of the state's witnesses. Well, that sounds similar, but that does not mean she could not be fair. Jurors are told the defendant is presumed to be innocent and that the state has the burden of proving guilt beyond a reasonable doubt. It should come as no surprise that some of them will have critical questions about the state's evidence. Surely, bold and emphasis added, surely a juror does not demonstrate unfairness merely by asking sharp questions. The court went on to say, jurors are told they must not form any definite or fixed opinion about the merits of a case until they have heard all of the evidence, the arguments of the attorneys, and the instruction on the law. There is nothing in the record to suggest that juror McCoy violated this instruction. Emphasis added to this part. She may have been forming impressions as she was hearing the evidence. God, what did I just tell you? What did I just tell you? She may have been forming impressions as she was hearing the evidence, but we do not know what she may have thought after hearing the entire case and discussing it with the other jurors. It would be unrealistic to assume that jurors do not form impressions as they are hearing the evidence. That is not improper, as long as the juror does not decide the case before it's concluded. Thank you. Thank you. Thank you. I said that 3 times. I get it. But that's the point I was trying to make. Just because my questions might suggest I am interpreting what you are saying in one way or another, that does not mean that I have made a conclusive opinion or that I'm not capable of listening to what you are saying and processing that in context of all of the evidence that's been presented and doing so fairly. Here, even if juror number 1 may have been forming impressions as he was hearing the evidence, that is not improper. Okay, agree. And it certainly does not mean those impressions have not and will not change after hearing all the evidence and argument and after discussing the case with the other jurors. Again, agree. The Washington court recognized that a juror may only be removed for misconduct if there's evidence that the juror violated an order of or instruction by the court. It concluded that, unlike a juror who visits a crime scene, reads news articles about the crime, or speaks to witnesses, Juror McCoy's conduct was not clearly shown to be a violation of any order or instruction. Whether her questions were too numerous or too suggestive are very subjective issues. To say that she was guilty of misconduct would require a characterization that is a matter of opinion. What a great case, man. The same is true here of juror number 1's questions, particularly when viewed in their entirety. Washington, the case, also criticized the trial court for failing to question Juror McCoy to determine whether she thought her questions violated the questioning procedure, stating that many potential juror misconduct issues can be diffused that way. Because the trial court simply assumed she had prejudged the case or could no longer be fair, based solely on her questions, the trial court's finding lacked record support. You guys see this here where it says ID right there? That is a cite. That is a reference to the case. So when they're saying here, this isn't the plaintiffs just telling you, take our word for it. No, this is actually citing back to the case and interpreting what was being said. Here, the defendant has requested not to interview juror number 1, and there's no reason for one on this vacuous charge. Washington expressed concern about the precedent that would be set if it were to approve the lower court's decision to remove Juror McCoy. Quote, the credibility of the process would be undermined if it appeared that a judge was deciding which jurors could serve based on the inclinations they may have shown by their questions. What a very well worded quote from this case. Thank you, appellate court. I'm going to repeat that. The credibility of the process would be undermined if it appeared that a judge was deciding which jurors could serve based on the inclinations they may have shown during their questions. Translation: if the judge is viewing those questions and playing a game of pick'em on which of the questions seem to express less bias or more bias, wouldn't that undermine the jury system as a whole? I think it would. That is a risk not worth taking, particularly here with the public interest this case has generated across the country. Rather than discuss, Washington defendant relies heavily on Allberger versus Harbison. This response is just savage. In Allberger, the trial court determined jurors' questions and comments were not objective and unbiased and removed the juror without questioning him concerning his expressed views. The appellate court affirmed because the trial court, quote, held a superior advantage over this court in determining the full force and effect of said jurors' questions and comments. Because this opinion does not recite what those questions and comments were, unlike Washington, we cannot know if they were so flagrantly biased that no other interpretation was plausible. That's clearly not the case with juror number 1. Defendant claims Allberger supports the proposition that questioning a juror under those circumstances could reinforce his prejudice or bias without cause. Allberger says nothing of the sort. In fact, it is utterly silent on this point, except to say that the court was in the best position to make the determination. As Washington observed, many potential juror misconduct issues are diffused that way. Finally, plaintiffs note that cases cited in paragraph 4 of the motion all involve jury selection, not the disqualification of an impaneled juror. So when you're talking about jury selection, you're talking about before any of the evidence is received. That seems to be a different stage of the trial, and different rules would apply. A potential juror may be excused if there is reasonable doubt as to his impartiality, but an impaneled juror may only be removed for misconduct. Washington's observation that a judge removing a juror for perceived harsh questions could undermine the judicial system applies with more force when a party litigant tries such a strategy. If litigants are empowered to remove jurors they do not like based on claimed harsh questions, this will become a prevalent new tactic. The parade of horribles argument. If there is ever a situation where a juror's questions might be deemed misconduct, this is not it, not even close. Because defendant has failed to show any misconduct by juror number 1, the motion to disqualify should be denied. So, how do we feel? How do we feel about that? How do we feel about the motion itself and the responses that were provided, or the response provided? So when I was reading the motion, I kind of gave you my impression of the concerns that I had with how that motion was being drafted, how the motion was being argued. I thought it was unfair. I thought it was asking for an impossible task of any person and kind of superimposing or projecting my interpretations of that question being asked by the juror as suggesting of, well, rather that I could read their mind. I think this motion is being denied summarily without a lot of fanfare. When I read the response and I read the motion itself, I really think the motion is going to be denied, and I can't see more than 5 to 10 minutes of argument on it. Unless there's a reply that puts all of the questions almost verbatim in. Even so, I can't see. One, get me past the ability of the judge to ask questions of the juror. No, you can't. Because the judge is in control of the courtroom. The judge has the ability to say, Mr. or Ms. Juror, can you be impartial? Have you formed an ultimate opinion on the case? Why, no, Judge, I haven't. Yes, I've been asking pointed questions, but it's because I've been wanting information based on what I was interpreting the information that had been presented in prior testimony. And I know that people are saying they didn't use their peremptory strikes. That's why that wasn't even included in here. This isn't really a for-cause dismiss. I mean, it is, but it's very different than we just got it wrong in impaneling a juror. Right? What you would have wanted, what would have allowed for the disqualification is that the juror withheld some preconceived bias. For example, if they asked the question, do you happen to be retired law enforcement? And the juror said, why, no, I do not. But then during trial, the juror asked a question coming from retired law enforcement, that would be grounds for dismissing the juror. That would suggest that that juror lied to get on the jury. Bye, juror, you're gone. But when you know they're prior law enforcement, when you know they're prior law enforcement, you already have to understand that by allowing that person onto the jury, that prior law enforcement, retired law enforcement is going to view information being presented in a skeptical manner. That's what their training and experience tells them to do. They knew that. They did not issue peremptory strike. They did not remove that juror for cause. That juror made it on the jury. So this was something. Oh, this is great. I don't know if you guys can see it. Let me see. Focus. Scott just sent me a text message. That's weird. That's Inception. said that one of the fans just sent him this mug that says Raid on it. I guess it's Southern Febreze. That's fantastic. Scott, I really hope you enjoy that. And I hope you're not drinking coffee. It's late. It's too late to drink coffee. All right. So I have given you my 2 cents on that. And that's kind of where things stand. I don't know what other impressions have been given from whether it's Peter Tragos or I know Kurt was talking about this earlier. I don't know if they matched what my assessment was, but I read that skeptically as hell. And I think that going down that road of trying to read the minds of jurors and remove them for what we perceive to be bias, that's a stretch for me. And that's a dangerous road I don't want to walk down. And I can't imagine the judge is going to do that either, even if the judge is being overly cautious, because here's the flip side of that. Let's say the judge removes the juror. Now you get the appeal by the plaintiff. You remove the juror. We would have won. So let's see. Della Sandor, thank you. Plaintiff should be monitoring LawTube. Great ideas. Thank you. Andrea Christensen, coming in late. The celebrating harvest is done. Glad to hear. Arctic Ginger, is it possible they're using jury consultants? Yes. I can almost guarantee you there's jury consultants being used. Retired Nana, Uncivil Law agrees with you. With a few, I don't care. I can see that because some of it is I don't care. Auntie in Arkansas, let's do that. We can check Ian's progress and see how he's doing. Share the page, share the screen. We know how to do this. Extra Life, Ian Runkle. Look at that. You guys are awesome. You guys are amazing. So you guys are absolutely amazing. 13,954. I really, really hope that that's a happy Ian Runkle waking up at 2 a.m. to start this chat. Come on, baby. I want to see Ian wake up, see that thing, and smile and realize that we've knocked off a heck of a lot of progress and he's got more to go. For those of you just tuning in, this is Ian Runkle's charity live stream, 24-hour charity live stream to raise money for the benefit of the Stollery Children's Hospital Foundation. Last year, he raised over $50,000. This year, I'm hoping he can raise even more. So I have made the comment that I have a link that's in the top of the chat. Please go and if you can, if you are able to, only if you are able to, please consider donating. And I say please consider donating directly because oh my gosh, look at that. We just hit over 14,000. Over $14,000. That's amazing. I am saying that please consider donating directly because 1, you get to see the track bar. 2, I am going to be giving everything from this stream to that charity. So all of it's going there. The problem is that YouTube takes 30% off and I would rather that end up in the charity's pocket and not YouTube's pocket. Okay. I'm only leaving the super chats up there so that people can, if they find it more convenient, do that way. But it's with the understanding that 30% is coming off the top. So please, if you can, consider going to the link rather than just doing the super chat. Okay. Kristen, M96, replace jurors with robots. Rob. Oh, I just thought about that. I have a robot jury. And Kristen made badges. All of my jurors now have badges. I would say we don't need a stinking badges, but this jury needs stinking badges. So all the jurors now have badges. Thou shalt not remove a member of this jury. Braxton Heaps, what's the legal definition of an opinion here? There isn't. Sir Merrick, I love how closely Rob matches what Uncivil was saying earlier today when he was reading this motion. Great minds. Nikki Lewis, 6 times court docs uploaded today to the court website. Let's see. Do we have additional documents? Are these two fighting and arguing over what we are or are not disclosing in this deposition? Let me do a quick check here. WB COP. That is the little screen captcha that I spelled wrong. VFX. Search the docket. Jack Kowalski. Let's see the case. What was filed today? Jack Kowalski. Notice of confidential correspondence, motion for clarification, notice of confidential information with court filing, and a notice of filing, notice of confidential information with court filing. Okay, so one of these, I really wish it would tell me the filer. So Howard Hunter filed the notice of confidential information. He filed both of them. So we have confidential information amounting to 88 documents, 88 pages and 178 pages that were filed in this particular case. And then we've also got Rutro. Hang on, let me share. Before I do that, hi, Kurt.
Hello.
How are you?
I'm doing very well. How are you doing?
I'm doing okay. I was just checking out documents, and did you see I covered the response,
Yep.
the plaintiffs?
Yeah, I covered them both today earlier.
The
My
chat.
my response to both was mostly laughing at John Hopkins' general direction.
Well, and I thought the plaintiff's response, I mean, that one case was immediately on point and directly on point. And it's like, nope, I'm not doing this.
Yeah.
So you were aware that also J Hatch had to sit for a corporate depot today,
Yep. Mm-hmm.
and that they argued
Because they
about
might
what
have
they
said
were.
some things on the stand that could have been perceived as potentially not fully accurate.
Yep. So
Mm.
after that, I am being informed that the following documents were shared or were
Mhm.
filed. So this one was filed by J Hatch. So pursuant to Florida rule of judicial administration, I'm filing here with document containing confidential information. The title type of document is Defendant Johns Hopkins All Children's Hospital Notice of Filing Affidavit of Angela Green. So an affidavit.
Mm-hmm.
Then entirety of exhibits A, B, and C.
Mm-hmm.
Then this one. This one is the supplemental disclosure and motion for clarification that they filed under seal. But then the clerk issued this.
Non-compliance. Nice.
So for those of you that are just listening in and not reading, so after those two things were filed by Mr. Hunter, the 88 pager and the 178 pager, motion for clarification, all that stuff saying this is confidential under seal, do not seal it or do not let other people see it. The clerk says, the Sarasota clerk of the circuit court has reviewed your filing dated November 3rd, which was identified by you as containing confidential information. The clerk has determined that the information in this document is not subject to confidentiality, as noted in Florida Rule of Judicial Administration 2.420D1B. The records shall not be held as confidential for more than 10 days from the date of this mailing, unless a motion is filed pursuant to subsection D3 of the Florida Rules of Judicial Administration.
Nice.
So clerk is going, I know you don't want people to see this, probably for very obvious reasons, but
It's devastating to you in your case and your goodwill and charm.
oh yeah,
Yeah.
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 Your Honor, I don't want anyone to see this. I
It
don't want
might-
to see this.
It might somewhat tarnish the reputation of John Hopkins because perhaps they have some problems they'd prefer the public not know about in further detail.
Yeah, I just can't. I right now, and the thing is, with Mr. Hunter filing this motion for clarification, I knew that the judge was speaking from the bench and saying, I could not be more clear about how broad I am viewing this discovery.
Yeah.
Everything that is relevant, if it has a scintilla of a scent towards this relevant issue, you turn it over. And Hunter's like, but we don't want to. So
Yeah.
I imagine Monday's going to be a very, very angry judge. Very angry judge.
They effed around and they're on the find out portion about it. Look, this is not that complicated. You guys are the ones that opened the door. This is all on you. Okay, John Hopkins. I don't know whether or not this stuff was admissible before, but what you did, you went on the stand and you said a lie. And there's evidence that can now be used for credibility purposes, if no other purpose. But the jury's not going to know this difference, nor are they going to care. So now all this stuff gets to come in because we have all this evidence that points to the contrary. So credibility is always relevant. So congratulations, you outplayed yourself. No, we've never had any problems at John Hopkins. We're a fantastic hospital. Everyone loves us. We're great.
Wild Sage with the Monty Python reference. Solid Monty Python reference.
Yeah.
Solid.
That was about my
Blythe
response. That was about my response was laughing and chortling in their face.
Blythe Burke, thank you very much for the very generous super sticker. That's a reminder that everything from this stream is being donated to the charity. So,
Oh, that's very nice.
yep. Equality, reminder that you can donate or you can claim charitable tax credits in Canada. Sorry, not sure about US or other countries, is a win-win situation. Magical Mary, Rob, how they know which juror since they were told not to put the name or number in questions? They can recount. I don't know. Retired Nana, Rob, did you notice that the audio played out the jury presents on Thursday of a known call between Beata Kowalski and Kathy Beatty sounds exactly like the one played as the defense evidence that was testified to as not Kathy? Go back and listen. I will. Andrea Christensen, I saw that earlier. Celebrating Harvest is done. Congratulations, Baby Gator. Thank you for the gifted memberships. Nikki Lewis, this won't even happen in place when the jury asks. No. This won't even happen in place when the jury asks.
No questions.
I'm
No
misconstruing that,
questions.
I guess.
The question mark is the word.
Oh, yeah. This won't happen when the jury asks no questions. Yeah. But Florida allows the jury questions, so I don't know how they get around that. Carla Vieira, could the motion be a smokescreen to distract? Nope. They really want that jury.
The motion is a sign of desperation. They're desperate. They're clinging to the last life raft, my friend. It's all over but the crying.
Yep. Ryan Man, why we see they want to see bias, let the judge grant their motion to disqualify. Amy Evans, hi Robbie, you're fun to listen to, smart and cute. Thank you. Michelle Maynard, Chester Mafia, a little bit of both. Jennifer Cochran Fent, why is this an issue if the judge let the questions in? Yes, they have the opportunity to object to the questions and have the judge rephrase them. So that's another thing. Michelle Maynard, is this a move by the defense to strong arm the jury, find for us, or will get rid of you? No, the jury's
never going to find out about this. This is all going to be disposed of in 5 seconds.
Yep. Jennifer Johnson, weren't the questions discussed and ruled by the judge? Yes. Before they were presented to the witnesses? Yes. How is a motion supposed to even be taken seriously? Because they make it sound very scary. I know a bunch of people who read that motion who were very concerned that the juror was going to be kicked off. And then I read it and I was going, oh no, we're fine.
No, I laughed pretty hard.
Yeah. Henhouse Bath Company, thank you for streaming tonight. Needed a distraction from being diagnosed with breast cancer this week. Henhouse Bath Company, I'm very sorry for that. You have a journey in front of you. Fight. You've got keep fighting. You can beat this. You can absolutely beat this. So cheers to you as you go about that endeavor. You can beat this. Kick cancer's ass. Just kick cancer's ass. L Booth for all the kids. Thank you, Ian. Thank you indeed. Ian's up to 13,152. Actually, he's up to 14,831. You guys are amazing. E. James, juror number one may have some experience solving complex problems, questions based on what was not covered and info they felt they needed. Healthy skepticism. Yeah, the jury doing their job. Matt Bond, objection. They're trying to beat my spiffy with questions. Yes, they were. Heather, question to defense. Are you telling this jury that you are upset that the jury is jurying and is listening to the evidence?
Yeah. Jury is jurying.
This jury, your juror bot has a this jury.
Nice.
You are a part of this jury in the robot jury.
Very good.
You've got a badge. Going on. Scarlett Sullivan, thank you for covering this case. Thank you. Danielle McClellan, question. J. Hatch's cited case law doesn't reference disqualifying jurors who asked biased questions, correct? It was a miss. It was a bit of a miss.
No, it was all about dismissing jurors as part of the panel when they're doing the initial voir dire to figure out who's sitting on the panel. That was when those cases were relevant, not jurors who are already sitting. So their cases were off point.
I thought so too. Jolyn Elliott, I just asked my child about Yeet, and then he proceeded to say Yeet, Yeet, skeet, skeet, and she aggressively yelled at me to never do that again before storming off. I felt compelled to share. Sandra Snedden thought about pledging, but decided to donate. Wonderful. Ruth Barrett, why can the jury ask questions? Florida. And apparently they embrace this very, very fervently.
Some jurisdictions allow it, some don't. It's things that are being experimented with.
Yep. This is a phenomenal username. Mispronounced name is should not be the same as shall not here. No, it is not.
Those are two very different things.
Very different.
Very different things. Yeah. Should not is optional. Shall not is not.
Correct. Heather, Rob, you notice RA's shirt had crisis cleanup on it? I did. Seems like he should be able to deal with the situation. I think so too. Manners, I'm with RA. I can't even look at earwigs without having flashback to Star Trek 2. Why did you bring that up in my mind? Thank you for that. That is going to keep me from sleeping tonight. Don't do it. Don't, Kurt. Earwigs. Jennifer Woolsey, Rob, will the evidence from J. Hatch be able to be used in other cases? If it's a systemic issue with the hospital, you think that's not relevant in other med mal cases around the same time?
Probably also part of the reason John Hopkins would strongly prefer that evidence not come to light, because other lawyers may be interested in some of that evidence in future cases.
I know. Isn't it funny that we might know a lawyer, hypothetically speaking, perhaps in the realm of possibility, not too far way removed from the initial thought process, who may or may not practice personal injury law, possibly, but not guaranteed in the state of Florida?
Who may possibly have potential interest in this as it may impact his clients? Could
And
be.
who for perhaps maybe hypothetically, not really just speculating 100%, not forming any conclusions. Maybe that's why you don't see a whole lot of opinions being expressed on a certain platform.
Could be.
Brianna Pinkney, sitting in my car an hour until showtime. Love FNF and your sensitive coverage of this trial. If anyone's in Las Vegas area, come see Carmina Burana at the Smith Center. We have 4 shows this week. Please do so, folks. If you are in Vegas, please check that out. Carmina Burana at the Smith Center. Missing Pieces, very clever username. The Heart Thing, yes, the little thing. So disrespectful to the children and families. This hospital doesn't want to own anything. Weed, SBF said he felt he only had 60,000 of unread emails. He was not overwhelmed.
He may be feeling more whelmed now.
Would you call him overwhelmed, underwhelmed, or just whelmed?
His internet access is going to be somewhat curtailed in the future.
Shall we swoop and talk about certain internet access being taken away from certain persons?
Swoop. Yeah.
So, Mr. Sam Bankman-Fried. Mr. Sam Bankman not so freed.
Mr. Sam Bankman imprisoned.
Mm-hmm.
Mr. Sam Bankman number, whatever his prisoner number will be. Yeah.
Let me see if I can pull this up. The U.S. Attorney for the Southern District of New York.
Yes. Who is currently facing 110 years statutory max for his misdeeds of defrauding people of billions upon billions of dollars. Jury spending just about 5 hours after a month thinking about it real hard.
So I don't really want to read Merrick Garland's opinion, but do you want to listen to the U.S. Attorney's statement on?
Sure.
It's 2 minutes.
Okay.
Present.
Ladies and gentlemen, we got him. Is that the statement?
I don't know if it's going to be that level of fanfare.
Sam Bankman-Fried perpetrated one of the biggest financial frauds in American history, a multi-billion-dollar scheme designed to make him the king of crypto. But here's the thing. The cryptocurrency industry might be new. The players like Sam Bankman-Fried might be new. This kind of fraud, this kind of corruption is as old as time, and we have no patience for it. When I became U.S. Attorney, I promised that we would be relentless in rooting out corruption in our financial markets. This is what relentless looks like. This case moved at lightning speed. That was not a coincidence, that was a choice. And it's also a message. It's a warning, this case, to every single fraudster out there who thinks that they're untouchable, or that their crimes are too complex for us to catch, or that they're too powerful for us to prosecute, or that they could try to talk their way out of it when they get caught. Those folks should think again and cut it out. And if they don't, I promise we'll have enough handcuffs for all of them.
Ooh,
Now, this verdict would not have been
nice.
possible without the incredible work of the career prosecutors from my office and the special agents from the FBI who have been there every single step of the way. We have pushed them hard and they have met the moment, and I am grateful for their service. Let me end with this. I understand that this case has gotten a lot of public attention. That makes sense. But the women and men of the Southern District of New York and the FBI consistently deliver outstanding public service on behalf of the American people, without fear or favor, and without any expectation of public acclaim. They do it because they believe in the rule of law. They do it because they love this country. They are patriots, and I'm proud to serve with them. Thank you, everyone.
Yeah, short, easy to the point.
That's
Works for
not
me.
bad. That's not bad. And it wasn't a whole lot of self-aggrandizing. It did very well. That's pretty good.
Not bad.
Tell you
I
what,
like it.
if you're going to commit a financial crime, not that you would ever do that or anyone would ever do that, you
No.
certainly don't do that where you could be within the jurisdiction of the Southern District of New York.
No, that would be advisable. They have a reputation. It's well earned. They do the financial crimes and they will eat you alive.
Oh yeah. Yep. And if you think something is complex, they're like, bet. We'll present it. We'll streamline it
Yeah.
and get a conviction in 4.5 hours. So
I am somewhat dissuaded from committing the financial crimes, Rob. I don't think that's
I am
life
too.
for me.
I very much do not like the idea of the financial crimes
No.
because
Please
let me see,
don't come
where are
after
we here?
Please don't come after me. I like my internet too much.
I do too. I like this. Please don't do that. Now, what was the biggest mistake that he made, do you think?
Oh, dude. It's hard to even say. I know what the answer you're looking for is testifying on the stand, but I don't know.
Oh, I don't know if
Like-
that's my answer.
Oh, okay. I thought that was what you were fishing for. I don't know what his biggest mistake was. Okay, I think the biggest mistake. I like the one exhibit where they had just this this one row of table that was showing the financial thing, and the last line of it was 8 question mark, which referred to $8 billion that was apparently missing. That was my personal favorite exhibit, the 8 question mark. $8 billion has gone missing. We have no idea where. That was good.
So the other thing about this is the speed. So they referenced the speed, and people were talking about how there was a lot of frustration. People said, why is he still out? Why is he not convicted? Why is he not being prosecuted? You guys realize this federal trial concluded within a year, like shorter than a year from when FTX filed bankruptcy.
Given the complexity of this in particular, that's
remarkable. I mean, when you're talking about data, you were talking about hundreds of terabytes of data between the systems. documents.
I know the
transactions.
SDNY is good, but it's hard to even believe that they're this good because this is so complex. Like even the guy who had to undo Enron was like, I don't know. When he testified to Congress, he's like, this is the most complicated nightmare I've ever seen.
Yeah, QuickBooks for FTX.
Yeah.
That's how we're gonna manage the entirety of an entire exchange. So let's
And
see.
a little
Forbes had
Slack messages and disappearing messages. That's okay for a multi-billion-dollar enterprise.
Well, and it's his testimony. Not his testimony. It's the fact that he went out at all. One, the crimes itself, stupid.
Talking to the press might have been his biggest mistake. Now that, yeah, I think that might be his biggest mistake. All the press interviews he did from the day, he was the day from the indictment coming public to the day of his arrest, all those interviews he did, I think that was his biggest mistake, probably.
The tweets, the deleted tweets, the "we are solvent, don't worry, we'll make everyone whole," the attempts to disrupt the bankruptcy proceeding, everything. The network talk show circuit he went on, or not network talk show, but the talk circuit he went on in the 1 month after the bankruptcy filing.
You think CoffeeZilla somewhere is having a little "I told you so" dance right about now?
Oh, I know he is. His Twitter feed, I think, is pretty hilarious.
Shout out to CoffeeZilla.
Yeah, CoffeeZilla, by the way, YouTube channel CoffeeZilla he was one of the people that really, when Sam was going on all these Twitter spaces and discussing the matter over and over and over again, CoffeeZilla was on that Twitter space and really started going after Sam Bankman-Fried.
Yep. Asking questions that were uncomfortable. Yeah.
Mm-hmm. And then the entire thing is you're sitting there doing it, and me and Ian were screaming at the monitor going, "Stop talking." Because exactly what we thought was going to happen happened. They literally played all of his statements, all of his prior comments, trying to explain how they just didn't understand. People just didn't understand.
Apparently they don't understand. Like parents don't understand. So he has to be the king of Bel Air.
So here's the article by Forbes. FTX founder Sam Bankman-Fried was found guilty of multiple fraud and conspiracy charges Thursday, bringing an end to a month-long trial in which prosecutors accused SBF of stealing and using billions of dollars from his own customers. I think the first 2 days of testimony was presenting photographs of the yacht, the mansion, all the money stuff. You want to get a jury invested in a case and learning information, you show them that stuff up front. Bankman-Fried has maintained his innocence, and his attorney, Mark Cohen, said we will continue to vigorously fight the charges. Bankman-Fried faces a maximum possible sentence of up to 110 years. I thought it was 115.
What's 5 years between friends?
Yeah. What's 5 years in the context of 110? House passed the $14.3 billion aid package for Israel. Oh, I don't want to read that. I just want to read this part, that little break headline. So SBF, 110 possible years. When is his sentencing? Hang on. SBF.
Ides of March. It's on the Ides of March. March the
28th.
15th. The 15th. March 15th. It's the Ides of March.
Why is everyone saying March the 28th?
I heard March 15th.
March. It's in March.
March-ish.
3 months.
March-ish.
Why is it 3 months away? Because there needs to be a pre-sentencing report done. The PSRs, pre-sentencing reports are PSI, pre-sentencing investigation, pre-sentence report. Those are remarkably comprehensive. They assess the different factors that must be considered by the court in determining the appropriate sentence. In this particular case, I wonder how much weight the judge is going to place on his explanations. Because the thing is, you're allowed to maintain your innocence, and that can't be used against you. Although oddly, in the sentencing factors, it is considered the cost of the trial, right? I always thought that was weird.
Mhm.
But
Every word he said on the stand can be
is
used
is
in
sub
sentencing.
is to be considered. Yeah, they consider that.
The fact that
So
he effectively lied on the stand because the jury didn't believe him, right? So yeah, I know.
well, and you read some of the testimony and cross examination, right? The
I
tweets.
sure did. It was fun.
What a nightmare! What a nightmare! That is, and you know damn well that Mark Cohen,
Yeah,
who is a remarkable defense attorney,
yeah,
if you're going to have a defense attorney that's representing you in a complex trial,
yeah.
that's kind of one of the ones you want.
I figure if he's lucky, he'll get out when he's eligible for Social Security. That's a good version.
I don't know. What do you think? 20 years?
I was thinking more like 30, but yeah.
Didn't they what they give Elizabeth Holmes? 30?
No, they gave her about. She was eligible for a max of 12. She got, I think, 12 or 13. I forget which number it was, but yeah. I was very disappointed. I thought she should have been maxed out at 20, to be honest.
That's the problem with a lot of these white collar crimes, is they just. But then again, Holmes was tried in California.
Yeah,
This is SDNY. I
yeah.
can't. And this judge he's funny. And by funny, I mean I would not want to be on his bad side ever in my entire life. No, I don't care if I'm an attorney or a party in that case. No,
I like this judge, though. I like the way he has control and command. I like the way he's like running the show. I respect
that's what
it.
I mean. That's why I don't want to be on his bad side.
It's like, I'm running the show. I'm the captain now. Yes, yes, you are.
Oh,
Yeah.
I don't know.
Yeah.
I can see the 30. I'll get behind 30. I think 30 is appropriate.
Yeah. Maybe you can shack up with Bernie Madoff and they can have tales about their wonderful journeys together.
Well, and the people that are saying, was the SBF the crime of the century? Mama Jama. No, not even close. But
Well, several $billion is gone.
that's
'Cause
true.
what did they recover? Something like 7 billion out of 15.
Yeah,
So $8 billion is missing still. So a lot of people are out a lot of money. So
that's
that's a
true.
lot. $8 billion is noticeable. Billion here, a billion there. Suddenly you're talking about real money.
Oh, okay. So he has the second trials going forward on the 5 more charges.
That too.
Oh,
That
oh.
too.
So we're gonna get more charges.
Bernie
Is he
Madoff
gonna
died?
testify at
did I
that
miss the
one
memo?
too?
Okay. He can't check off with Bernie. Bernie's apparently dead. I missed that memo. Sorry. Yeah.
What a,
Oh,
I
well.
mean, well, the case concluded kind of in the way that I anticipated, that he would be guilty on all counts. I anticipated that he would not be able to resist testifying. There's no
Yeah.
way in hell that Mark Cohen said that was a good idea. No
Yeah.
way.
Yeah.
That was his insistence.
Yeah.
And the testimony was as horrible as one could ever imagine it being.
I look forward to reading the transcripts of his testimony someday. That'll be fun to read on stream someday. 3 months when it becomes public, we can read it on stream together. It'll be fun.
Oh, and when I was making the comment to 8 billion being nothing, no, what I was saying about that was when you talk about the crime of the century, it's not about the amount that was stolen. It's I view the crime of the century as being the complexity of the crime. This one, when you got down to brass tacks, it wasn't that complex. Now, unwinding the money trail was a pain in the butt because there was a lot of transactions. But complexity-wise, it wasn't. Money was coming in. He reflected as being a positive balance on the books here, but was using it here and not reconciling those two. The entity that he was allowing to trade on the platform could go negative, never had any punishment. He lent a lot of money to himself. He lent a lot of money to his parents. He lent a lot of money to a lot of people to allow him to buy yachts, mansions, properties. And he put a very shiny face on it in the form of influencers that he paid lots of money, millions of dollars, to just say, hi, this is a phenomenal thing. You can trust this.
Mhm.
It's not the most complex thing in the world.
Well,
So
I suppose you can just say it was a con. So yeah,
well, now
a
he's
very sophisticated.
convicted.
Is there? Yeah, there you go. Very nice. From con to con. Very good.
SRN, too bad he messed up extradition. Can't charge the campaign issues. Lucky DNC. The campaign finance issues were never going to be the big part of this. Yes, they would have, the discovery on the issue would have been there, but that's going to come up anyways. That information is coming out. For those who think that information is just not going to come out, Chapter 11 bankruptcy cases, that's going to come out in the bankruptcy case. Period.
Fair.
So my curiosity is that now that the conviction is there, once the sentencing is done and you basically have that resolved, then the adversary proceedings in the bankruptcy case get to go forward, which includes the adversary proceeding against the parents. I have predicted that I can foresee the parents being involved in some fashion of criminal charge,
Yeah.
and they didn't
And
have
then
to
we
extradite the
talked about
parents.
Dad being involved. So yeah.
Mom was directing the campaign contributions. Campaign finance charges is pretty, not to say it's easy to prove, but when you talk about the federal government and their ability to handle financial crimes, I'd be surprised. I'd be surprised. All right. Let's see. Oh yeah, Karate Cat Mom. Now about the doctors, Bankman-Fried. Ryan YYC, thank you for get the memberships. Okay, we're gonna catch up on super chats, and I'm gonna land this plane so that Ian can get going at 2:00 in the morning my time. I want to do this too. I'm gonna set up. I know it's gonna be really early, but I'm gonna set up a redirect so that you guys can go and land there. Just make sure you hit the like button and hit a little reminder icon so that when he does go live, it is going to be 2 a.m. He knows that he's going to be kind of running solo for a bit. And I don't know, Kurt, are you going to jump on with him at any point?
Yeah, I'm definitely going to make an effort to. And I think Ian did a great job last year. We had a lot of fun on the stream last year, and he raised a lot of money for a really good cause. And he wound up really punching above his weight compared to a lot of other people. He wound up doing surprisingly well for basically a solo channel. And I'd love to see that reflected again. So if you guys can pop by, if you have a couple, even $5 to throw in the tin to help the cause, it would be wonderful. And if you don't have $5, if you can just stop by to show him some encouragement and love, we'd really appreciate it. It's for a good cause. You know.
Yeah, honestly, just hitting the like button, just hitting the like button and showing up and dropping a comment in the chat.
Retweet it, tell your friends about it, put it on your Facebook, text the link to some friends, text them, put it in a group chat. I know you guys have a group chat out there. Spread the word.
Aurora W. Rob, let's get to 10,000 for Ian before he starts the chat. We see your 10 and raise you 5. And I will tell you that you guys, the generosity that all of you show to these charitable events, especially when it benefits a good cause, is absolutely remarkable. I will never cease to be amazed by how much I have seen in the last year being on YouTube of how generous people are when it comes to good causes.
Yeah. We even raised money when I did a charity thing. We raised a couple $1,000s, and no small part thanks to you, for thyroid research. And so we've all done some good charitable work over the years, and this is a great cause, unless you don't like children. So if you're against children, don't donate. Show everyone where you stand.
Oh gosh.
Hashtag I hate children. I do not support this.
Yeah. Don Burke, it's easy to go and donate to Ian. It is. Let's go ahead and catch up on super chats. Let's swoop and go to super chats. I'm going to keep an eye on this window. I'm going to remove it from the screen for right now, but swoop. Happy swoop. Love it. All right. Miracle Mama, thank you very much. The super sticker. Bridget, thank you. I don't believe this lawyer is that ignorant. Oh, this is Crowell's. She does not have actual knowledge. She might have information, but she would need to verify with Mr. Hunter, who is the actual attorney on this one. JM, there's a shot of what looks like Hunter blasting Shapiro when this first occurred. I think this is probably frustration quite a bit from the defense counsel in the Take Care of Maya case. If I was defending the hospital and this got brought up on the last day of evidence in the rebuttal case,
Yeah, that's great.
I'd be upset. Could this be a question of clean hands? I think that's one way of phrasing it. Yeah. Julianne Harrington, thank you. If reports show deceit, can defense be sanctioned? I think
This pretty
Mr.
much is the
Hunter,
sanction at this point. This is the sanction. All the stuff that comes in that wouldn't come in pretty much is the sanction at that point.
that
which
pretty
is-
much is.
which is perfectly fine. It's perfectly adequate.
However, seeing that Mr. Hunter filed a bunch of things under seal in his quote motion to clarify, I am just speculating on what that clarification he is seeking might be. And
No, when
perhaps
we
it
said
is,
this, what we really meant was.
yep, perhaps that motion to clarify is in reference to, you know, the judge saying everything is relevant. And Mr. Hunter's probably like, when you say everything, you didn't mean everything, right?
Everybody.
I am just guessing that's what that motion says. And I would not be surprised if we saw the judge either come out with a ruling over the weekend on something.
Can
or-
it just be one line? Did I stutter? Is that too much? Can the judge write that?
I don't know, but if he takes the bench on Monday, someone get that man. Like, I don't know what could calm him. He's gonna need like a foot massager under the bench, like for his feet, just to be there to keep calming him.
We'll send him a lawn lumber stress ball. That'd be good.
Oh yeah, you stress unicorn. See him pop that up. And,
The little horn pops up every time he gets stressed.
God. Or if the judge is just sitting up there and goes, like if the attorneys are arguing, the judge goes, Mr. Hunter, nope, screaming unicorn.
Can a judge just break out a yodeling pickle at some random intervals? Is that acceptable courtroom decorum? I don't remember any rule that says you can't do it.
I don't think there's a rule that says you can't. But I would die. I would die. Yeah. Hate to be J Hatch IT department right now. I would too. It's a lot of docs. Louise. Rob, if you were the plaintiff now, what would you be feeling and discussing? I would be buttoning up that argument so that come Monday, when they are sitting there and trying to argue how this is not relevant, I have every line cite, pin cite, everything completely ready to give the judge exactly what he needs. Like, this isn't relevant, doesn't show systemic. I would have every citation to the word systemic in any of those documents ready. And I would say, Judge, the documents from 2012 to 2016 say the word systemic failure 325 times or whatever number it is.
Yeah, that's good.
Yeah. Book Dragon KSC. I love that you all partner to do this with Runkle. I feel like this is the best plot twist at the end of a book. I hope it doesn't result in a mistrial. Oh, this is regarded. I don't know. Not now. The defense kicked this door open, and the judge has made that emphatically clear.
John Hopkins has no one but themselves to blame.
Yep.
It's all relevant as to character. That's sort of the bottom line. Like, the best you can hope for is the cautionary instruction. Yeah, this is just for credibility, not for liability. Like, anyone understands the difference. Like, it doesn't matter anymore.
They don't care. The judge has said it how many times? The defense put on a witness to say that J Hatch had the blessing of the Joint Commission. He uses that word several times, the blessing of the Joint Commission. And that might have been materially false or misleading. Yes, they get to refute that. And just imagine you're a juror hearing that in evidence.
Here's every time the Joint Commission said something other than blessing.
Yeah. Yeah.
Yeah, the blessing. Well, it's interesting because look at this.
Or you know what?
over
You
here.
know what I would do? I'd hold up
Look
a
at
stack of
this
documents.
photograph.
You know how many times that you see the word blessing in here? 0. You know how many times you see systemic failure? 300 and something.
Yeah.
Magda, thank you for the very generous super chat. Rose Lee, thank you for gifting a membership. Bop It, thank you for gifting several memberships. Kristen, one of my favorite channels. Thank you very kindly. Kathy Sawyer, thanks. Finally made a live stream. Thanks for all you do. Thank you for all you do. You are a member, and thank you for contributing. Danielle McClellan, thank you. Catherine Frazier, appreciate your coverage of this case. Thank you very much. Evelyn Roberts, thank you for the super sticker. Honk Banana, no. Motion for some sort of chinchilla odor merch. Possibly. Right now, I got to figure out how to do this jury. Faith M. Lawyers chose to take the fall for a client. Odds? Question mark. Not worth your bar
I
license.
understand the question. Yeah, it's like, yeah.
It's not worth your bar license.
No.
So,
Yeah.
I mean, you'll stick your neck out, but not like that.
Yeah, no.
Destiny
It's
Salazar.
it's like the criminal lawyers. So they tell their client at least one of us is going home today.
Oh God. Deathy Salazar for Ian. Also, Rob, did you ever imagine this trial would take this direction? Nope. I knew it would be complicated. There's no way I thought we would get here. Rachel Dueck, feel this like this is the defense trying to clean up dog poop off their shoes using tissue paper. Possibly. That's not that bad. An analogy. JPC, why don't all Florida courts allow jury questions? I think most of them do. I believe most do. DSN, thank you for the super sticker. Here for years. Rob, you need to cover this live on Monday. I will be out of town.
Very sad.
I know. This was supposed to go way earlier. Like it was supposed to be done.
But I'll be here on Monday. So
Yep.
are you going to do a wrap up on Monday night?
I don't see how I can.
All right.
I really
I'll try to do one on Monday.
Yeah, I really don't know. I'll be watching. I just don't know if I can. And I have trial on Wednesday. So
yeah, that's rough.
I mean, I can't imagine the jury. Well, I don't know if they get to introduce this evidence on Monday.
Yeah.
I can see a verdict pretty quick.
Yeah. I'll try to either live stream it on Monday or do a wrap up on Monday night.
Yep. So check Kurt out for that. Judy got this a little for Ian, plus a shout out for daughter. He inspired her to start streaming for her own CMN hospital with a slightly lower goal. Huh. Thank you, Ian. That is awesome and great to hear, Judy. You got this, that your daughter is streaming. DSN, thank you for the super sticker. Angelia Taylor, looks like to me the defense is trying to put lipstick on a pig. Swoop. Wild Sage. So it was a major stuff up having witness Anderson on the stand. Big mistake. Huge. Inconceivable.
Well,
and I think that
the problem wasn't necessarily having on the stand, but saying, "Oh yeah, the Joint Commission, they love us. They're super duper great. They love everything we do."
But it was because the guy only reviewed a 4-page summary. That's it.
Oh yeah. Well, in that case, yeah. Okay.
Well, but that was, and the thing is, the 4-page review, that was intentional. That was the defense attorneys.
How do you let this guy testify in the first place is my question. If all he did was do a 4-page review, how do you get past letting this guy on the stand? Your opinion is completely worthless.
Because they felt like, so the plaintiffs produced a witness that started to suggest at systemic failures. So the hospital felt like they needed to refute it. So they have a witness that says no systemic failures. But the hospital is concerned because they know these materials exist. And if they give these materials to any expert, the expert is going to have them and have the knowledge to testify based off of them. But if the expert is not given these materials, and you are somehow hoping that the foundation of their opinion is not attacked via what materials they were or were not allowed to review, this was the hospital not giving the expert the information the expert needed to give an adequate assessment of the hospital's.
Did the plaintiff side throw a hissy fit about this person being on the stand?
Oh no, they let him go. On the stand. And then they crossed the hell out of him. They wanted this. This was 4D chess. They knew the second that he started saying this and they started cross-examining him on it, they knew it would lead here.
Okay, well, then they definitely thought that one all the way through. So good for them.
I pulled up little snippets of how the testimony went, and a lot of the word choices in the testimony from the plaintiff's case in chief to how the defense answered. You could see the plaintiff's case in chief, the word choice, they used systemic, the stuff he wanted to go into it. but he couldn't do it because you can't kick that door open because you couldn't make the causal connection. But you know who could kick the door open? The defense.
Yep. Great. Unforced error.
Yep. Here to save your ass. Not
How
kiss
did
it.
they not, how did they not see that coming? How did
don't
John
know.
Hopkins lawyers not see that coming?
I do not know. I pulled an earwig out of a patient's ear the other day. Thank you for making sure I don't sleep tonight. Amanda Breck, please take a look at Shapiro's interview after court last week when he doubles down on hospital's performance. I'll take a look. I will. Actually, that's interesting. I do want to take a look at that. Joshua, thanks again for another great FNF and have a wonderful weekend, everyone. You too, Joshua. Thank you. Jen, love you both. Thanks for all you do. Grateful to have found this community. It's full of good people. Off to donate to Ian. Good. Thank you, Jen. Lynn, Oklahoma City judge, any info? I will cover that in the early part of next week. It's a long document to walk through, and we've done a lot of documents today. Hippo lover, we love you, Rob. Over Ian, what's the name of the robots brand? I want one for a special person. The robots themselves, those are made by Kristen M96 in the chat. One of them is being auctioned off on Ian's stream. So keep an eye on that. Ange Torres, we're trying to get a mistrial, or is Shapiro that young of a lawyer? That was just stepping in it. So Melissa Simok, the judge chooses whether to allow the jury questions in Florida. I believe so, yes. Atticus, thank you for the gift of memberships. Faith M, defense better bring the wallets and toothbrushes. Possibly. Southern Mom, I read some articles about other JH facilities with issues following Joint Commission evaluation. Seems systemic. Did the plaintiffs know about this the whole time? Yes. This was vastly reported, widely known. Yes. And here is Kristen coming in to say what I just said. Someone asked about the robots. Ian's going to auction off a custom bot for extra life. So everyone bid if you want one. Kristen is the maker of bots. So as her little avatar suggests.
And also a nice person.
And a very nice person indeed. And she also made this jury tags.
And a Clemson grad.
And a Clemson grad, but I don't hold that against her or you. Christy Wingett, thank you. Ms. Pete, 3 guesses who's representing Alina Kushner. Swore I heard none other than Anderson. Correct. Anderson is representing Kushner, who is the person who said that they observed Sally Smith walking into their room wearing a white lab coat with J. Hatch embroidered on the side. All right, so let's check in and see where we are on the charity live stream, and then we are going to wrap things up. So Ian is up above $16,000. You guys are up above $16,000 as far as donations are concerned. You all are amazing, wonderful people. Please remember to go check out Ian's charity, the live stream event. You will be redirected to that at the close of today's video. Thank you for being here. Pampered Shelley, thank you. I messaged Ian and you. I have an item he can auction. I'll tell him to take a look. Like I said, you guys are all amazing. I really appreciate every single one of you for being here. To Kurt, who hung around to talk SBF with me, I very much appreciate you being here, my friend. I hope you are enjoying your travels to your parents and that you enjoy that. Let's go ahead and wrap things up. Kurt, what do you got coming the next few days?
Well, nothing really planned on the calendar right now because I'm currently traveling, so I don't have anything scheduled for release right now. So just taking a little break, but probably try to catch some of the stuff on Monday and Tuesday in the absence of Rob to figure out how this all goes so we can have a little wrap up. So I'll try to do that on Monday night and Tuesday night. Otherwise, just chilling out, and we'll see what next week brings.
Very, very good. Very good. So I am traveling. I leave basically Sunday, first thing in the morning, and I return back Tuesday and I have trial Wednesday. So I am going to be, I have not slept. I will sleep. Most of the month of November is going to be me sleeping. Lori Leanne, Veritas Mini Plane and Tenon Saw to be auctioned. Oh, very cool. Okay. Very, very cool. All right. We're going to wrap up. I'm going to do the outro and we will, we'll see you guys next time. Very much appreciate you being here. Happy Friday to all of you. Hope you have a wonderful weekend. Please check out Ian Runkle's charity stream. Donate if you're able to. And until next time, thank you guys for being here.